You have informed the other side. What urgency? No urgency. Heard, mister. What is your name? What is your name? Heard, Mr. A. R. Tahbildar. Mr. Appearing on behalf of Miss R. Devi, Deputy SGI, who prays for an adjournment on the ground that the conducting counsel for the respondent is indisposed. Also heard Mr. D. Rathi, who though concedes to the prayer of adjournment, has submitted that there is urgency in the matter and therefore a date may be fixed. Considering the submissions made by learned counsel for the respondent, the prayer is allowed. Let this matter be listed in the second week of November on a date to be fixed by registry. In the last week of October on the date to be fixed by registry. In orders column. Orders column. Okay. Okay. 20? Yes. Yes. List this matter before any other bench without me. On a date to be fixed by registry. The interim order shall continue till next day. Registry, pray before registry. Be louder. 21. You don't have an objection.
I have, but a date may be fixed below. On 23rd of this month.
No, no. Date fixing matter. Heard, miss, what is your name?
Appearing on behalf of Pivora Udas.
Heard, Miss Udas, learned counsel for respondent number 2. Also heard, Miss S. Roy, learned counsel for the appellant. Learned counsel for respondent number 2 prays for an adjournment on the ground of personal difficulty of the conducting counsel, to which the learned counsel for the appellant does not raise any objection. Hence, the prayer is allowed. Let this matter be listed in first week of November on a date to be fixed by registry.
Yeah, please. My lord, I have filed an IFC bill, my lord, in MSc appeal, my lord, for releasing the, my lord, deposited amount, 50% deposited amount. My lord, let it be come after vacation, my lord, Diwali vacation after next week, my lord.
Okay.
Orders column, publish.
My lord, I pray for mention listing of a new CRP filed for tomorrow. My lord, there is some urgency. We have challenged the order of the lower court. If my lord allow the matter to be listed tomorrow.
What is the urgency?
My lord, if we have challenged the lower court's order, if money suit, which is past ex parte. So our application filed under Rule 9, Order 9 of Rule 13 has been
Whether
dismissed.
execution case has been filed.
Yes, my lord. So the execution order will be passed, if my lord, if not listed tomorrow.
Okay. Okay,
Can it be listed tomorrow?
Monday,
My lord, Monday after vacation.
Wednesday, Wednesday.
Great. my lord.
Might we please your lordship? Lordship, with the consent of the other side, I beg to mention item number 33 of daily list.
What is your name?
M. Kolita, I am for the sole respondent. I am appearing on behalf of Miss M. Sharma.
Heard Miss M. Kalita, learned counsel for the respondent, who prays for an adjournment. What is the ground for adjournment?
Lordship, my senior is not keeping well today and respondent, petitioner.
Prayed for an adjournment on the ground of personal difficulty of the conducting counsel. You are for?
No, not this.
She submits that she has informed the learned counsel for the appellant regarding her prayer for adjournment, who has no objection to the said prayer. Hence, the prayer is allowed.
Lordship, date may be fixed.
No. Registry will fix the date.
Apply to lordship.
My please, your lordship, I want to list one case of testimony appeal under orders column. Any date may be given.
After they will leave
After-
it. Yes.
May please your lordship, I beg to mention item number 22. Here the matter is, the respondent number 7 has expired, your lordship. So today we have filed our substitution petition. Item 22.
I am appearing for the respondent number 8, my lord, in this case.
No, what is your prayer?
The respondent number 7 has expired, your lordship. So we have filed our substitution petition. So the
So-
matter may be fixed after 2 weeks.
Lordship, any date be fixed and it may come in the others column and they may find their substitute.
Heard, Mr. What is your name?
IJ Singh 4.
For the
On-
appellant,
Yes, your lordship. On behalf of BK.
IJ Singh,
Singh 4.
Singh for. Learned counsel appearing on behalf of
Mr. BK Das.
Mr. B. K. Das, learned counsel for the appellant. Also heard Miss S. Roy
For the respondent number 8, my lord.
for respondent number 8, as well as Mr. A. Lal,
For respond 2 to 6.
respondent number 2 to 6. Learned counsel for the appellant has submitted that as respondent number 7 has expired, the appellant has taken appropriate steps by filing a substitution petition today only, and therefore prays for an adjournment of 2 weeks. Stop. The prayer is not opposed to by learned counsel for the respondents, other respondents. Hence, same is allowed. Let this matter be listed in the 3rd week of November on a date to be fixed by the ministry.
Lordship, it did be fixed, otherwise it will not come, Lord.
No, let registry do its work.
Lordship, I beg to mention one MSc appeal. It was part heard before your lordship. Lordship allowed mentioning for the first week of August. It did not come, my lord. So maybe on 28th of August, my lord.
28th of,
August, 20th of this month, my lord. The part heard matter, my lord.
okay.
I'm okay.
May I please, your lordship? Lordship, with the consent of the other side, I beg to mention item 7 of the daily list. Can it be fixed after 4 weeks, lordship? The interim order may be continued.
Item number,
Item number 7 of the daily list.
you are for,
I'm for the petitioner.
you have informed the other side.
Yes.
I am for the respondent 2 and
You have no objection.
means for 1.
I'm for one.
Heard, Mr. What is your name?
A Kashyap, AJ Kashyap, Lord.
Heard, Mr. A. J. Kashyap, learned counsel for the appellant. Also heard Mr. S. Deka, learned counsel for respondent number 3, as well as Mr.
As thus, I'm reading on
As
behalf
thus.
of M. Dutta.
appearing for respondent number 1. Learned counsel for the appellant prays for an adjournment, to which the learned counsel for respondent raise no objection. Hence, the same is allowed. Let this matter be listed after 4 weeks.
After 4 weeks.
After 4 weeks.
The
The interim is there.
interim order may be.
The interim order may continue till next day.
There are 3 matters connected with each other arising out of the same proceeding. One FAO, 2 CRP. The FAO is fixed on 11th of November My prayer is, my lord, these two CRP may kindly also be fixed on 11.
Okay,
I am providing the number.
you,
I am
Men-
respondent in all the three.
you mention it in the mention memo.
Obliged.
May I please your lordship, I beg to mention one RSA for listing. In the last week of.
RSA listing pray before registry. Oh, in hearing column,
My lord, I have already filed the application
what application?
for listing.
So
The,
it will be listed automatically. Why mentioning?
but till then the matter has not been listed. In the
When
last,
have you filed?
I have filed 1 week before, my lord.
You go to registry, pray for listing. If it does not get listed, then make a mention.
My lord.
May I please your lordship? Lordship, with the consent of the other party, I beg to mention item number 31 of the daily list, my lord. Kindly one day accommodation may be given, my lord.
You are seeking adjournment.
Yes, my lord, on behalf of MJ Burwa,
Heard, Mr. What is your name?
A. Ali.
A. Ali, learned counsel for the respondent who prays for an adjournment for the day. He submits that he has informed the learned counsel for the appellant regarding his prayer for adjournment, who has no objection to his prayer. The prayer is accordingly allowed. Let this matter be listed. Prayer is accordingly allowed. Stop.
My lord, kindly fix a date, my lord.
No
Please
date.
proceed.
Seeking adjournment and also praying for fixing a date without considering the difficulty of court is
May I
not.
please, my lord?
Obliged, ma'am.
Item number 12 is a transfer petition, my lord, and I would like to withdraw that transfer petition and consequential stay order may be vacated. This is my humble.
Your husband or wife.
I'm wife,
Item number
12. Umpu Muni. Versus Anjan Morgan.
heard Mr. B. Deka, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant transfer petition. The prayer is allowed. This transfer petition is dismissed from withdrawal. Accordingly, the stay order granted earlier stands vacated.
Deeply obliged, my
lord. I have one urgent matter. I filed a RSA and RSA was admitted. And I also filed a petition for stay of the present proceeding. This honorable court issue notice. Last matter was listed on 13/9/2024. Pass an order that after appearance of the respondent, the interim prayer will be considered. Now, I come to learn the respondent, they appeared, made appearance. Now, what happened, my lord? Although they appeared, they started execution proceeding, my lord. And tomorrow, we come without, no notice has been served in that case also. I come to learn that tomorrow they are going to execute a preliminary degree for measurement by land to partition. So,
Only measurement.
yes, my lord. So, my
Then
lord,
Wednesday,
my lord, tomorrow
they will measure only. Let them measure on Wednesday. Then in the causeless, the other side will come to know on Wednesday.
Yes, your lordship. I beg to mention orders item 25.
Yes,
In this case, MS M. Chaudhary, senior is there for respondent number 3. He has some personal difficulties today to appear.
we have informed the appellant's counsel.
Text, call him and text also. No response, my lord.
Then we'll not pass any orders now.
Yes, ma'am.
When
he
the matter
reaches-
is called,
Yes, ma'am.
then we'll allow it. Let the matter be called for.
Obliged.
May it please your lordship, I beg to mention an IA for early hearing. also. IA in RSA. For early hearing.
Wednesday.
Yes.
With regard to item number 5, with due consent, can it be fixed on 31st of October? Item number 5, you know.
Why?
Due to some difficulty, your lordship, can it be adjourned to the year?
Heard Mr. A. Das, learned counsel for the petitioner. Also heard Mr. A.K. Gupta, learned counsel for the respondent. Learned counsel for the petitioner praised for listing this matter on 31st
October of this month, Your Lordship.
October due to some personal difficulty on his part. The learned counsel for respondent concedes to his prayer. Accordingly, same is allowed. Let this case be listed accordingly on 31st October.
Much obliged, Your Lordship.
May I please your lordship, I may be allowed to withdraw for tomorrow. Criminal petition 849.
Criminal petition, you are before wrong court. This court is not taking up criminal roster. Yes,
Please, lordship already settled dispute, dispute already settled between parties, lordship.
you are for,
I'm for petitioner, lordship.
heard miss, what is your name?
Adhikari,
P.
Adhikari.
P. Adhikari, learned counsel for the petitioner, who submits that as the matter has already been amicably settled between the parties, the petitioner do not intend to pursue this matter and seeks leave of this court to withdraw the instant civil revision petition. Stop considering the submissions made by learned counsel. The prayer is allowed. This civil revision petition is accordingly dismissed on withdrawal.
Item 1 and 2.
Lordship, my learned brother may he argue first because the ejectment decree has been passed against him. If he permits, then I will argue.
But why have you filed this?
Because Lordship, what happened so far the defaulter issue is concerned, it has been decided against me. Because the suit for ejectment was against in respect of defaulter as well as bona fide requirement. It's a second round of litigation, second revision.
No, suit for ejectment was filed on the ground of defaulter.
Defaulter as well as bona fide
Bona fide
requirement.
So defaulter issue was decided
Then
against.
ultimately, in the last round title, the appellate court found that he has not defaulted. Because why? Because the honorable court
But bona
directed
fide requirement was there.
there, according to the
So
appellate court, but that has been challenged.
Ejectment decree stays.
Lordship.
My lords, they filed a suit, my lord, for eviction of the my lord defendant on two grounds. My lord, defaulter and bona fide record.
No,
Then
no,
suit was-
before Mr. Purkasta,
My lord.
Mr. Bhuya.
Lord.
The decree is still in your favor.
Lordship.
They have preferred an appeal,
They preferred, Lordship, they preferred an appeal,
separate appeal.
separate appeal. Initially, what happened, Lordship?
And in
I am
that
certain.
stay has been granted.
Lordship. Decree was passed by the trial court, holding that he is a defaulter as well as the house is bona fide required. So as against that appeal was preferred by the tenant. So that appeal was by the appellate court, the trial court judgment was upheld. So against that, the tenant preferred a revision before the honorable court. The honorable court interfered with the judgment of the passed by the appellate court, holding that the due date to be ascertained, because when the court is going to decide the issue on question of defaulter, so due date is to ascertain. So accordingly, after setting aside the appellate court judgment, remanded the matter to the appellate court to decide afresh. Thereafter, appellate court decide the appeal afresh, holding that he is not a defaulter, but rather the appellate court found that the premises bona fide required. So there is on that ground, the decree of ejectment has been passed, appeal has been dismissed. So against that, they preferred a revision before the honorable court. And I, being an aggrieved by the findings of the appellate court, so for the defaulter part is concerned, I filed a separate revision.
Okay.
That is the position.
So
Because
their
that is why
revision
two
is-
revision.
Their revision is 41.
Lordship,
Second one.
Lordship, second one.
Item number 2.
Second.
Okay, you want item number 2 to be taken up first.
First.
Okay, let us take up item number 2 first.
But so far as the, my lord, bona fide requirement is concerned, the court says that, my lord, appellate court, as well as the trial court, that the landlord is the best person to judge. Therefore, my lord, whether this is the, my lord, exhaustive proposition of law, or there is some exception. That was not taken into consideration. Only they said, my lord, in para 5 of their issue number 5. Basically, my lord, there was no issue framed by the court below. Whether, my lord, suit premises required for bona fide requirement, required for bona fide use and occupation. That was not the issue. No issue was framed. While deciding issue number 5, court has come.
What was issue number 5?
Issue number 5, my lord.
Page number.
Correct. Page, my lord, 126, or should find issue number 5. Whether the plaintiff is entitled to decree for eviction of the defendant and his articles from the suit room as mentioned in the Schedule B. And while deciding issue number 5, court has come to the conclusion that suit premises is required. On the findings that the plaintiff is the best judge to, my lord, take a decision regarding
Where is page number?
page number 126, issue number 5.
Yes. Yes, what is the submission?
Submission is that, my lord, whether that proposition of law is exhaustive or, my lord, inflexible, so that there cannot be any deviation or departure. I have, my lord, in my, while taking grounds in justification of my prayer or my submission, my lord, I have referred to number of decisions. Whereas court has, my lord, dealt with the question of bona fide requirement. In holding that, the approach of the landlord must be honest, fair, and it must not be tainted by any oblique motive. Now, my lord, also kindly see the pleadings of the, my lord, plaintiff. They said, my lord, we served notice, but before serving notice, my lord, plaintiff approached the defendant making a request to vacate this premises. 2 options was made, my lord. 2 options was offered. Number 1, either to pay the rent and continue the tenancy, or if you don't pay the rent, vacate the land. There was no any whisper in the notice regarding bona fide requirement. And lordship, kindly have a look, my lord. My lord, para 9 of the plaint at page 79. 79. Has the lordship got, my lord?
Yes.
Para 9, page 79 of the plaint. What is the amendment made pertaining to that particular issue, my lord? May I read, my lord?
Yes.
That the plaintiff, before sending pleader's notice, pleader's legal notice, on several occasions, verbally requested the defendant to leave the room and deliver the vacant position thereof to the plaintiff, as the plaintiff requires the room for his own use in developing, repairing the damage of the said room. The plaintiff had only one educated employment son who is intended in running a business for his and his family bread. and buttered, but the defendant did not show any response towards the request of the plaintiff. My lord, why I am referring this particular paragraph, my lord, as well as the pleading, before sending pleader's notice. Therefore, my lord, that is a subsequent approach of the plaintiff, making a request that I need the suit premises for my son so as to accommodate him. But what about your stand in the notice? Did notice at all disclosement of the fact that the suit premises at all request? Lord, record, whether record has come or not, that notice is not with me. Therefore, this is a casual approach.
No, but what is your submission?
Therefore,
That
since
there
it
is no such contemplation in the notice.
yes,
Where is that notice?
Lord, possibly it is on the record, I don't have the copies. So the exhibited,
Was it exhibited?
that was possibly exhibited. Is the plaintiff? who is
No,
correct.
you cannot make submission on possibilities. You have to be fully prepared.
Then I have to check up the record, my lord.
So when will you check the record?
Today itself, my lord.
When, after you make your submissions before the
Not before-
court?
before that.
You-
Because earlier
If
occasion
you are
also-
not ready for argument, you should have prayed for adjournment.
No, I cannot, because he is the last man to allow this prayer.
But you seems to be not ready.
My lord, on the earlier occasion also, my lord, I made a request to court, kindly allow me to go through the records.
You can go through the record. There is no bar.
Then, my lord, I will go through the records, also fix the matter immediately after reopening or first week of November. By that time, I will check up the matter. Because this is a very crucial question, my lord, whether you can have a casual.
Because unless you are ready, how will you assist the court?
That's right. That's right. Only that part of the, my lord, I didn't check up the record.
Yes,
Lordship, that maybe again, it may be listed
No, no,
at
no,
top
no,
of the list.
no, no, no.
I am not
Yes,
top
yes.
of the list.
Yes, yes, yes. My lord, today itself I will go through. Because
How-
my
Because that is not
challenge-
exhibited.
my
They have
challenge-
exhibited only 4 documents, sir.
Lordship is to take into consideration whether his approach is at all bona fide, fair, honest, sincere,
no,
or
I'm
it is a
there
casual
to,
approach.
but your submissions shows that you are not prepared.
Because I didn't go through.
Heard Mr. R.K. Bhuya, learned counsel for the petitioner in CRP case number 100/2022 and respondent in CRP case number 41/2022. Common order above. Also heard Mr. A.K. Purkayastha, learned counsel for respondent in the CRP case number 100 and petitioner in CRP case number 41/2022.
Lordship. November.
Learned Mr. A.K. Purkayastha, the learned counsel for the learned counsel has submitted that though this matter has been listed at the top of the list, however, he could not go through the records and he prays for allowing him to go through the records of the court so that he can make submissions in this case. The prayer is allowed. The counsel for both the sides may go through the records available in the court if they desire to do so. Let this case, when,
Six.
6th
of November.
On 6th of November.
let this case be listed again on 6th of November at the top of the list.
My lord. My lord, I may be allowed to go.
Yes, I have reflected it
My
in
lord,
the
yes,
order.
I'm obliged.
Obvious.
I go.
These two matters, my lord, are between the same parties. But a little bit different. The second case, my lord, CRP 140,
Which should we take first?
140, that will be better. This CRP, my lord, arises out of a suit which was filed by the landlady. I am the tenant. Now, the landlady, my lord, she filed the suit in the year 2010. And the suit number was title suit number 11/10. In that suit, she sought my eviction on twin grounds, my lord. First claim is that I defaulted in the payment of rental for the month of May 2009. That is her first claim. And since I have defaulted, that is the allegation, my lord, I should be evicted. And her second ground was that plaintiff number 2, who happens to be the daughter of plaintiff number 1, landlady, she requires the suit property for her own bona fide use. Her name is Nazifa, the daughter of landlady. And for her necessity, the landlady required the suit property, and that was the second ground, my lord, for seeking my eviction.
No, this CRP is proceeding ex parte.
Both CRP. Both.
There is an order.
There is an order.
Okay, okay.
Now, the second CRP is filed by me. Since I was the plaintiff in the subsequent suit. I am coming to that, the facts part, my lord.
Okay, let us go one by one.
Both are connected. I will have to take the story of both the cases together, my lord. So the first suit was filed by the landlady seeking my eviction on 2 grounds, my lord. And the suit number was 11/10. During the pendency of the suit, my lord, on 29th of May 2011,
yes,
there was a fire incident in the area where the suit property situates. The fire incident didn't happen in the suit property, it happened somewhere else. But ultimately, the fire was so ferocious that it ultimately embraced the whole area, and it also take within its sweep the suit property. And the
suit property is a room.
is a room
Okay,
standing on a plot of land which is measuring around 900 square feet.
okay.
Now, the suit property, to a large extent, my lord, got damaged in the fire incident. Save and except that one toilet room survived, which was part of the suit property. And that toilet, my lord, was never used as a toilet, but was used as a godown for the purpose of keeping my items. So though it was a toilet, my lord, it was used as a godown. That survived. So after 29th of May 2011, when the suit property to a large extent was damaged, my lord, I filed a suit which was numbered as 19/11. And the connected CRP is, my lord, the second one. The previous one, 153/24.
Yes.
My prayer in my suit, my lord, was that the landlady should be directed to restore the property to its original status. And in case she refuses or neglects the order of the court, then in that event, I may be permitted to restore it back, with a condition that whatever I spend, that may kindly be recovered, because I am only a tenant. And that is under Section 6 of Assam Land Urban Areas Rent Control Act. I have a right to continue. And for that, I can ask for restoration. Both the suit continued, my lord, and there are so many incidents that has happened which may not be required at this moment. Ultimately, what happened, the evidences were closed long back in the year 2018. And for one or the other reason, there was a need felt by the parties that the suit property needs to be measured. Because in the tenancy agreement, this area of the suit property was mentioned as 10 feet by 59 feet. But the toilet that I am talking about, my lord, was beyond the 59 feet. And ultimately, even the plaintiff also agreed, and the measurement had to be carried out. First, it was refused by the trial court, matter reached to this Honorable High Court in the year 2019, and the Honorable High Court allowed the measurement, and ultimately it came that it is more than 59 feet. It is almost 90 feet. So
90.
90. In the meanwhile, my lord, in the year 2022, an application was moved in both the cases. In the case where the landlady was plaintiff, and also in the case where I am the plaintiff. In my case, the defendant moved the application. In the earlier case, the present defendant are the plaintiff, my lord. They moved the application. They informed the court, trial court, that landlady has expired, which fact was known to us, and in the meanwhile, substitution had been carried out. And the landlady had left behind her son and 2 daughters. One of the daughters happened to be the plaintiff also, my lord, in the previous suit. After her death, her son, who all along has been looking after the suits as her attorney holder, because either the plaintiff on her own used to come in the court, or she used to send her son, who was duly authorized by virtue of a power of attorney, and he is Nazrul Hussain, my lord. His name is important, my lord. And he also adduced evidence as PW1 in the suit filed by his mother, landlady.
Yes.
And I am the tenant, my lord. In my suit, they were defendant and he adduced evidence as DW1. So her mother never entered the witness box. Though she was there as a party, she appeared through her son most of the time. And even she led evidence through her son, because the son was ultimately taking care of the entire property. So he was competent enough to speak about the tenancy, the necessity of the tenanted premises for the bona fide use of her mother or for her sister. So he was competent and he spoke about that. He adduced evidence. His evidence, as I have said, my lord, completed in the year 2018. In 2022, he informed the court that the suit property has been sold in 2016.
Sold to whom?
Sold to 2 persons, my lord. One is Anwar Hussain and the other is Manwar Hussain. Both are brothers. Anwar is elder, Manwar is younger. Now these 2 brothers, my lord, out of 2, Anwar Hussain also had adduced evidence as PW2.
In whose suits?
In the
In
suit
the
filed by the landlady.
Yes.
And he had supported the factum as pleaded by the landlady, that she required the suit property for her own use. This is very interesting. He supported her story.
When he adduced his evidence?
2014, my lord.
Before the purported sale.
Before the proposed sale. And he knows about the pendency of the suit. Thereafter, he purchased. Well, fine, my lord. But this entire fact of sale purchase kept under wrap, my lord, and it was never informed to any court, whether the matter had been pending before this Honorable High Court or before the trial. In 2022, May only, for the first time,
yes,
this fact was brought by way of an application. And the application, as I have said, my lord, was moved by Nazrul Hussain, who all along have been looking after the suit of his mother as her attorney holder. After her death, he stepped as a legal heir. Now his status changed, but he continued to appear. His status changed in the sense, my lord, that now he was appearing as an heir of his mother. And he also got the power of attorney from other legal heirs. So now again, he continued to look after this suit. He said in his application that I was totally unaware as to when my mother sold out the property. And now only when after her death, I was cleaning the trunks, I could know that the property has been sold out. When he made the application, he also made a prayer that the suit which was brought by mother now doesn't require our continuation. Our continuation in the sense that the legal heirs of landlady. And the subsequent purchaser should be brought in as a plaintiff in our suit and our name should be struck down. That was his prayer before the learned trial. In my suit, which I have filed for restoration of the suit property, similar identical petition was moved by him saying, I cannot now continue to remain as a defendant since if anything has to be done now, it has to be done by the purchaser. And he should be incorporated as a defendant and our name should be struck out. Both the prayers were allowed by the learned trial. Now this is under challenge.
Okay.
Now, my lord, my first contention so far the suit by the landlady is concerned. There were two grounds, my lord.
Sued by the landlady, that is the second, this CRP.
140, my lord.
140.
She died, my lord, on 21st of May, 2021. And the property had been sold, my lord, on 26th of April, 2016.
Yes.
Now, there are two reasons to challenge, my lord, the order so far passed in the previous suit, that is the suit filed by the landlady.
Okay.
My lord,
Where is the impugned order?
if you are looking at 140, my lord, the impugned order is at page 115, my lord. It starts at page 116, my lord.
Yes.
And excerpt 14.
Yes.
May I read out? Or may I
You,
give
you
the
may
brief?
continue at your own, as per your own scheme.
My lord, the application when it was allowed, our basic contention was that plaintiff, so far the landlady or her legal heirs are concerned, Nazrul Hussain is concerned, it is his choice whether he wants to continue with the suit or not. He is the dominus litis, he is the master of his own suit. If he wants to withdraw, he can do so. If he wants to abandon, he can do so. But can he come to the court and say that in my place, so and so should be brought in as a plaintiff? Another reason is there, my lord. The cause of action is very peculiar to the landlady. What was her claim? Her claim was that rental for the month of May 2009. This is very important, my lord. May 2009 has not been
When
paid.
the suit was not purchased by
My lord, the suit has been purchased only in the year
suit
2016.
16.
I am not coming to the fraud part, which has been practiced on the court when the information was never conveyed to the court, either before this Honorable High Court when the matter was sub judice here in the form of CRP or before the trial court. But even if we go by what they have pleaded, May 2009. Now, I will be showing Transfer of Property Act when the purchaser becomes entitled to rental from the day the ownership passes. So he cannot, the purchaser cannot say, I am also entitled to or can take of May 2009. And this defaulter part is only available to the landlady. She can seek my eviction, or the subsequent purchaser can file another round of suit and he can seek eviction on grounds which is available to him.
Yes.
Second part, my lord, is that the property is necessary for the bona fide need of my daughter. Now, this purchaser cannot claim the same relief on account of the daughter of the landlady. So both
But
counts.
she
fail,
was
my-
herself plaintiff.
Yes, ma'am.
She
Now, the
can
subs-
continue.
She could have continued, or her son or daughters can continue, but they want to abandon. They say we are not interested at all in the suit, so we don't want to pursue the suit.
Yes.
And in our place, so and so, the purchaser should be brought in. So far the CRP 140 is concerned. the entire consideration by the learned trial court, my lord, in my humble submission is fallacious. It's on wrong footing, my lord. Now,
Putul.
now, my lord,
Transfer of
the
property.
purchasers,
Transfer of property. Yes.
the purchaser, very interestingly, they are not before the court. Till date, they have not moved any application. One of the purchaser, as I have already stated, my lord, that he adduced evidence as PW2. And the suit property, one of the boundary men is the PW2. He is one of the boundary men. Second, my lord, the sale deed also has a recitation that the matter is sub judice. So far, landlady and tenant is concerned. May I take your lordship to page number
2016 sale deed.
16 sale deed, my lord.
Okay.
Page number 95, my lord. Fifth page of the sale deed, my lord. CRP 140, my lord.
Yes.
Para 3, my lord.
Yes.
That the land in a small dilapidated house in the form of toilet is free from mortgage, lien, charge, or any other form of encumbrance except civil suit of eviction against a tenant of any nature whatsoever. And in the case the same is found to be otherwise, then the vendor shall have the right to be indemnified by the vendor. So, my lord, Anwar Hussain, who is one of the purchaser, who is also PW2, who adduced his evidence in the year 2014, even in 2016, cannot plead ignorance that I was ignorant about the pendency of the suit. One person can say that I adduced evidence 2 years back. On the date when I was purchasing, I was ignorant, very fine. But here there is a clear-cut recital, my lord, that the matter is still sub judice.
Yes.
Kindly come to the same page, my lord, West, who are the boundary men. Anwar Hussain, Manwar Hussain, the two brothers.
Okay.
So they know, my lord, about the pendency of the suit. Now, my lord, before moving ahead, these two purchasers definitely have their independent right as a purchaser. They can also file eviction suit. Definitely, I am not here to guide them, but they have their independent right after having purchased the property, which right they have not exercised till date. Now, in their absence, the original plaintiff, can he come before the court and give the advice or give the application saying that I may be replaced by so and so? Now, even if the learned trial court allowed the prayer, my lord, I am coming back to the original legal point. The bona fide need is very peculiar to the landlady because she was speaking about the necessity for her daughter. Now, this purchaser cannot claim that the need of the daughter is also to be pursued by me. And the default part, my lord. Now, come back to the provision of law, my lord. Kindly come to section 55 of transfer of property.
Yes.
Section 55, my lord, subsection 4. This pertains to, my lord, rights and liabilities of the buyer and seller. The seller is entitled, A, to the rents and profits of the property till the ownership thereof passes to the buyer. Now, my lord, I pause for a moment. If you are asking for default for the month of May 2009, the ownership has passed only on 26th of April 2016. So May 2009, the default part cannot be pleaded or taken aid of or advantage of by the purchaser. 55(6).
The sale deed was executed
On
on
26th of April 2016. It is another matter, my lord, that the information was conveyed to the trial court only in May 2022 by way of this application, which was ultimately allowed. Now kindly come to 55 subsection 6A. The buyer is entitled to, where the ownership of the property has passed to him to the benefit of any improvement in or increase in value of the property and to the rents and profits thereof. So the ownership has to first pass to the buyer so as to enable him to seek the rental. Now, my lord, kindly come to the application that was filed, same CRP 140, my lord. Annexer 8, page 84.
yes.
An application, first page, my lord, an application under Order 1, Rule 10 to read with Section 151 of the CPC to strike out the name of the heirs of late Sayyida Rubia Begum, she is the plaintiff landlady, my lord, as plaintiff, and to aid as party plaintiff the purchasers of the land, namely Anwar Hussain, Manwar Hussain, as purchased by serial number so and so, dated 26th April 2016. Now, what is their claim, my lord? Kindly come to para 1. The predecessor in interest of the substituted plaintiff, namely Sayyida Rubia Begum, had instituted the instant title suit for eviction of the defendants on the ground of defaulter and had also claimed the area rent in respect of the tenanted suit premises. Now, again, I come back to this first paragraph itself ought to have made the learned trial court vigilant that these cause of action are very peculiar and personal to the landlady. These cannot be transferred. Ownership has transferred, not the previous right of collecting the area rent or taking advantage of any default, alleged default, my lord, for the month of May 2009. That next para, during the pendency of the instant suit, the plaintiff number 1, namely Sayyida Rubia Begum, after long illness had expired on 21st of May 2021. Now kindly come to para 4, my dear. The mother of the petitioner, Sayyida Rubia Begum, empowered Muhammad Mohiuddin Laskar to alienate her 900 square feet area, 6 by 1/4 Lassa. So the attorney Muhammad Mohiuddin Laskar, by exercising the powers had on 26th April 2016, executed and registered a sale deed in favor of Anwar Hussain and Manwar Hussain by serial number 107, dated so and so. Be it stated that the fact of alienation of the land was not known to the petitioner at the stage of execution and registration of sale deed, but much after the demise of Sayyida Rubia Begum, the plaintiff number 1, when her dwelling room was getting clean, then the deed of sale by which her attorney had executed and registered the land came to the notice of the present petitioner, and hence this petition. Photocopy of the registered deed of sale is annexed herewith for perusal by this honorable court, and the same is marked as Annexure 1. Now, this gentleman all along continued to act as an attorney holder, even adduced evidence as PW1. Second important, my lord, let us move ahead, para 5. As the burned down room was situated within the area sold out property as sold out by serial number so and so to Anwar Hussain and Manwar Hussain, so the petitioner as well as the other substituted plaintiffs have now lost their interest in running the present title suit in absence of their title upon the said land and gutted house, and hence filed this petition praying for striking out their name as plaintiff and exonerate them from contesting the suit as legal heirs of late Sayyida Rubia Begum, and be pleased to add the purchasers as party plaintiff. Order 23, my lord, of CPC authorizes any plaintiff to abandon any suit. For that, I need not inform the court. But if I don't inform, the court may impose cost on me. That is only rider. If I have continued for long, all of a sudden I disappear from the court may impose cost so that the trouble that has been faced by the defendant can be compensated. But if I can come and inform the court as to the logic for which I am withdrawing, perhaps the court may exonerate me from imposing cost. That is only thing, madam. But I have the freedom as a plaintiff to abandon suit at any time. Now here, when he wants to abandon, there is no trouble, my. But when he suggests, and unfortunately the learned trial court accepts the suggestion that I should be replaced by so and so. Now kindly come to the conduct part, my lord. Next, come to page 88, the power of attorney, whereby Sayyidah Rubia Begum had authorized Muhyiddin to sell the property. It was executed on 6th of June, 2011. But the actual interesting part, my lord, is at page 90. Nazrul Hussain happens to be one of the witness. So when he knows that he is merely looking after the suit and his mother has authorized someone else even to sell, whether he was not obligated to keep a check, let us assume that he was totally ignorant, which is unlikely, my lord. But whether he was not legally duty bound to keep an eye as to what was happening by her mother, by his mother. So he is one of the witness to the, and second witness, my lord, is Anwar Hussain, the purchaser. When these facts, my lord, this is nothing but fraud. And when we try to show the honorable court below, that Supreme Court says that when an order from the highest court is obtained, and if there is some semblance of fraud being practiced to the highest court, even the lowest court is authorized to strike down the order of the highest court. Only that power is available when the order has been obtained by exercise of fraud. Even that order was ignored. I am talking about, my lord, Supreme Court judgment of.
No.
United India Insurance Company Limited versus
Citation.
Rajendra Singh, my lord. Citation is, my lord, 2000 EIR SCW 835. Party name is United India Insurance Company Limited versus Rajendra Singh. Here the apex court has said that even if the order has been passed by us, and if it comes to the notice of the lowest court of the country, that the order has been rigged out by exercise of fraud, the court is entitled to strike it down. Now, my lord, here the same court was being dealt with fraudulently. Now, my lord, moving ahead.
Fraudulently, you are saying that there is a probability of fraud.
Apparent, my lord, and I am showing another thing, my lord. So far, my own suit is concerned, 19/11.
But in this CRP, your main plea is that since the property got transferred to the, on a later date, to the new plaintiffs
My lord.
who are added,
Wanted to be added, my lord,
they,
as plaintiff, replacing the previous plaintiffs.
that has been allowed.
That has been allowed.
Is there any stay on?
My lord, yes, stay.
Stay is there.
Stay. And interesting, my lord, that the original plaintiff, the suit was proceeding, my lord, since 2024. The stay only I prayed on the last month, my lord. On 3rd of September, this honorable court was pleased to grant the stay. Prior to that, the suit was continued. The original plaintiff did not take any step to substitute the new plaintiff, nor the new plaintiff came forward to make any sort of application. I was keeping an eye as to what they are doing right now, even in the absence of the stay. So I don't know, madam, what kind of suit they are continuing with. Now, my lord, the second important part that I was trying to highlight. So far, my suit is concerned, my lord, 19/11.
No, before that,
That has
where is the impugn order in this?
impugn order
case?
is same, my lord, in both the cases. It starts at page, my lord, 115, annexure 14, my lord, and the relevant portion starts at page 116. So far, 116, 117 is concerned, my lord, the contents of the petition and the objection has been referred to. Kindly come to page 118, second para. The learned advocate for the petitioner has submitted that since the title over the property has been transferred and the present plaintiffs have lost their interest over the suit property, hence addition of purchasers of the property as plaintiff by striking out the present petitioner is required to be done before the survey measurement of the suit property. A survey application was pending, which was ultimately allowed by this Honorable High Court in 2019, but still that was pending for one or the other reason, my lord. Convinced upon the submission of the learned advocate of the petitioner, this court has taken up this instant case for adjudication. The learned advocate for petitioner have placed reliance on the judgment of Honorable Supreme Court at the time of hearing of the case.
You are aggrieved partly by the impugn order to the effect it allowed joining of name of
My lord,
Anwar Hussain and
my lord.
Manwar Hussain. First part of the,
So far, they have lost interest. They don't want to
You are
continue.
not
I have
agree.
nothing to say, my lord. Nobody can force them to continue with the suit. It is their choice, my lord. Even without aiding, they can continue, my lord. If they want to pursue. But they are very categorical that they have lost interest in continuation of the suit. And therefore, they want
now the impugn order makes two orders.
two others.
One to strike out the names of the
My lord.
legal heirs of the earlier plaintiff. And second to add.
Add.
You are not against the striking out of the name.
My lord, it is their choice.
No, already order has been passed.
Striking out, my lord.
Striking out of the names.
I have nothing to say, my lord. If their name is struck out, I am saying their name after striking out cannot be replaced by the new purchaser.
So you are aggrieved by the second part.
Second part.
Second part.
Second
only.
part.
Okay.
It is their choice, my lord, to get their names struck off
Okay.
or not to continue. Kindly come to page 121, my lord. Same order. Second para. Or I may continue with the first para, a small paragraph. The original plaintiffs have lost interest and title over the suit property. As such, they prayed to strike out their names and prayed for the implement of the transferee as plaintiff. From the contention of the petitioner as well as from the above stated provision of CPC, it appears CPC, my lord, order 22, rule 10 was referred to on the preceding page, my lord. It appears that the transferee of the suit land is the necessary party in whose absence the suit cannot be properly and conclusively adjudicated. Further, it also appears that if the transferee of the suit land is not added as party plaintiff, there may be multiplicity of the suit and the defendant will not be prejudiced in any way if the names of the present plaintiffs are struck out. The learned advocate for the opposite party has raised the contention that the suit land was transferred in violation of order dated 4/8/11 in Miss J case number 15/11, wherein by the parties were directed to maintain status quo over the suit property, which makes sale by the original owner as null and void. In this regard, in Yadula so and so, referring to the judgments of the Honorable Apex Court in age so and so, Surjit Singh and other judgments, my lord, has been referred to. Next page. Fourth line, after referring to so many judgments, that where the sale deed is executed in breach of injunction issued by competent court, breach of injunction should not render the transfer whether by way of an absolute sale or otherwise ineffective. And the party committing breach may doubtless incur the liability to be punished for the breach committed by it, but the sale by itself may remain valid as between the parties to the transaction, subject only to any direction which the competent court may issue in the suit against the vendor and held as follows. While deciding an application under Order 1 Rule 10 in a suit for a specific performance, the court can order implement of a purchaser who files application for being joined as a party. Now, my lord, I pause for a moment. So many judgments have been referred to. From which judgment this passage has been brought in, nobody knows. Now, let us again read
And
the
this is
passage.
not a suit for specific performance.
No, my lord. And interestingly, what it says, while
But,
deciding an
but you did not raise the plea of section 55(4) and 6 before the
I
trial.
raised, my lord.
It
In
is
my
not,
argument, I raised.
it is
My
not
argument
reflected.
perhaps was not noted down, my lord. I raised so many things. Your lordship has just found that I also said that the sale deed itself is illegal because it has been done in the teeth of an injunction order. I am coming to that also, my lord. That part, though referred to, there is no consideration at all, my lord. Now kindly come to last page, my lord, the passage that has been in inverted comma reproduced from some judgments which is unknown to me. While deciding an application under Order 1 Rule 10 in a suit for a specific performance, the court can order implement of a purchaser who files application. Who files an application? Here the purchaser is not before the court. It is another matter. The suit is not for a specific performance.
Yes,
Even the purchaser is not before the court. Thus, in view of the above discussion and the reason stated above, the petition is allowed. Accordingly, the name of the petitioners are struck off from the plaintiff as plaintiff as plaintiffs, and by invoking power under Order 1 Rule 10(2), the names of the purchaser of the suit property, namely so and so, are added as plaintiffs. Now, my lord, in the previous page, your lordship has come to find that an injunction order was referred to.
4811.
4811. What is its implication, my lord? And what was my submission? And what judgments were saying about this? Is there any consideration? Reference is there, but what is the consideration in the hands of the learned trial court? It appears, my lord, with all humility, that those were of negligible impact to the learned trial court. Now, may I take your lordship to the injunction order? Why I am saying, my lord, this is connected with CRP 153, but both matters are identical. Orders are almost identical, save and except 1 or 2 lines here and there.
Okay, no, in this case,
So if I am to sum
section
up,
55(6) and section 55(4) gives weight to your submission. So you have a case that the trial court could not have directed addition of strangers as plaintiff without any application made by them.
and even if they make an application, my lord, in that suit, they cannot. They have independent right.
They, new cause
Why,
of
my lord?
action.
Because they cannot speak about default prior to 26th of April 2016, number one.
And the
Number two, my lord, they cannot speak about the bona fide need for daughter of landlady. They may have their own bona fide need.
yes, yes.
For those 2 reasons, my lord, this order is unsustainable and the plaintiff cannot give suggestion that so and so should be brought in replacing me.
Okay, what is your cause? But in the second CRP,
Second CRP, my lord. Now, second CRP will have also impact on the first CRP, my lord. In the second CRP, my lord, we made a specific application during the pendency of the suit that injunction may kindly be given and I should not be thrown out from the possession of the toilet or the godown that I was using, my lord.
Putul. Got the jobs. Yes. In second suit, second CRP, you are aggrieved with the same order.
Same order. Same order. In my case, they were dependent, my lord. The name of the dependent has been replaced or struck off and the new
No, in second
purchasers-
CRP, a separate order was passed.
Separate order.
In,
Separate order.
in the
because
similar, on the similar line.
Same line. Except one sentence, my lord.
Where is the impugn order?
It is last page, my lord. Page 125 it starts. We can skip, my lord, page 120. Only come to page 129, last part. The learned trial court has referred to order 1 rule 10(2) and then proceeds to the next page. The provision, second paragraph, page 130, the provision of order 1 rule 10(2) CPC makes it clear that court may at any stage of the proceeding, either upon or even without any application, and on such terms as may appear to it to be just, direct that any of the following persons may be added as party. Any person who ought to have been joined as plaintiff or defendant but not added, or any person whose presence before the court may be necessary in order to enable the court to effectively and completely adjudicate upon and settle the questions involved in the suit.
But in the second, before you make your submission,
My lord,
in the second CRP, the defendants were added, the purchaser were
added.
added as defendants. And unless they are added, how will you get your relief in the
My lord,
title suit?
My lord, before I further speak,
Because
let us go.
you prayed for restoration of the suit
My lord.
property.
First, my lord, my submission is, like I said in the previous suit, my lord, in the second suit, I am the master, I am the dominus litis. I will decide against whom I am to seek relief. And my belief or my seeking relief is backed by law, my lord. Kindly come to section 109 of TP Act. May I trouble your lordship by first speaking about section 52 and then 109.
Yes.
Transfer of property pending suit relating thereto, section 52. During the pendency in any court having authority within the limits of India, excluding the state of Jammu and Kashmir, any suit or proceeding which is not collusive and in which any right to immovable property is directly and specifically in question, the property cannot be transferred or otherwise dealt with by any party to the suit or proceeding so as to affect the rights of any other party thereto under any decree or order which may be made therein, except under the authority of the court and on such terms as it may impose. For the purpose of this section, the pendency of a suit or proceeding shall be deemed to commence from the date of presentation of the plaint or the institution of the proceeding of a court of competent jurisdiction and to continue until the suit or proceeding has been disposed of by a final decree or order and complete satisfaction or discharge of such decree or order has been obtained or has become unobtainable by reason of the expiration of any period of limitation prescribed for the execution thereof by any law for the time being in force. Now, my lord, this speaks about the principle of lis pendens. Matter was sub judice. Anwar Hussain was knowing full well when he adduced evidence in support of this previous suit as PW2 number 1. Number 2, my lord, he knows that in the sale deed itself, there is a recitation that one litigation is pending between the landlady and the tenant. He himself is one of the witness to the power of attorney, and he is also a boundaryman. He has full knowledge. Now kindly come to 109. Rights of lessors transferred. In my case, my lord, when I am speaking that I am tenant, I am a lessee, and my landlady or her legal heirs, they are lessor to me. Right of lessors transferring. Lessors transferring in the present case is the purchasers assignee.
Anwar and Manwar said.
I am the lessee, my lord. I continue to remain as a lessee.
Yes.
Be it in under the previous landlady or her legal heirs or the subsequent purchaser, till the date the subsequent purchaser makes any kind of demand to me. if the lessor transfers the property leased or any part thereof, or any part of his interest therein, the transferee, in the absence of a contract to the contrary, shall possess all the rights. And if the lessee so elects, kindly look at the language, and if the lessee so elects, be subject to all the liabilities of the lessor as to the property or part transferred, so long as he is the owner of it. But the lessor shall not, by reason only of such transfer, cease to be subject to any of the liabilities imposed upon him by the lease, unless the lessee elects to treat the transferee as the person liable to him. It is now my choice, my lord. The ball is in my court. If I elect that let the purchaser comes into picture and I want to seek the relief against him, I can do so, or I can continue to proceed with the previous litigation against the transferor, my lord. He cannot avoid his responsibility because what he has done during the pendency of the suit, he has transferred surreptitiously. So it is my choice, my lord. Now, my choice was never asked. I kept on objecting because I want the purchaser to come. The purchaser doesn't want to come. Why he should invite him, my
Let us read 109 again.
if the lessor transfers the property leased
Okay,
or any part thereof.
your landlady transferred it.
Yes, ma'am. She is the lessor
Yes.
and her legal heirs are now stepping into her shoes or any part of his interest. Here the entire interest has been transferred. The transferee, the purchaser, my lord, in the absence of a contract to the contrary, shall possess all the rights. And if the lessee so elects, be subject to all the liabilities of the lessor as to the property or part transferred, so long as he is the owner of it. But the lessor shall not, by reason only of such transfer, this is applicable in my case, cease to be subject to any of the liabilities imposed upon him by the lease, unless the lessee elects to treat the transferee as the person liable to him. So in my case, my lord,
So you may continue to
and that is
ask
back
the earlier landlady to
or her legal heirs, my lord, since she has departed.
renovate your suit
Fine.
premises.
And they are bound. And this is also backed by Supreme Court judgments, my lord. So I have not decided till now, my lord, and my choice was never asked. Interestingly, my lord, this provision was even quoted by the learned trial court. I was reading some
Read
passages,
the
my lord,
proviso for part,
my lord,
provided the transferee is not entitled to areas of rent
my lord.
for the transfer.
Provided that the transferee is not entitled to areas of rent, this is based on section 55 before the transfer, and that if the lessee not having reason to believe that such transfer has been made pays rent to the lessor, the lessee shall not be liable to pay such rent over again to the transferee. My lord, if I have paid rental to the original landlady, even during the pendency of the suit, without knowing that the transfer has been taken effect, my lord, that I am need not required to pay. And the third paragraph will make things more clear. The lessor, the transferee, and the lessee may determine what proportion of the premium or rent reserved by the lease is payable in respect of the part so transferred. And in case they disagree, such determination may be made by any court. Now, my lord, so far, partitioning of the rental that has accrued or that is being paid is not the subject matter right now. There is no disagreement because the party who has purchased, he never
Has
approached
not
any of the
claimed,
court.
has not yet
Not
claimed.
claimed, not even taken the burden of approaching the court, my lord, even to say that I have bought it. He is playing hide and seek, my lord. So I am also happy. If he doesn't want to appear, why I should invite him, my lord.
So
No, my lord,
so you intend to continue your suit against your earlier landlady in view of the fact that section 109 entitles you to elect
Right.
whom to make liable. Okay.
Kindly come to page 132 of the impugned order.
Yes.
Third paragraph, the title suit out of which the instant case arose was filed by the plaintiff or the tenant, and he sought reliefs against his landlord. The relationship between the plaintiff and the defendant, being the tenant and the landlord, are governed by the provision of the Transfer of Property Act 1882. Section 109 of the TP Act states as follows. The provision is quoted, my lord. Now kindly come to next page. From the above, it appears that the transfer of a landlord rights steps into the shoes of the landlord with all the rights and liabilities of the transferor landlord in respect of the subsisting tenancy. In Ambika Prasad so-and-so, it is held by the Honorable Supreme Court of India that the atonement by the tenant is not necessary to confer validity of transfer of the landlord's right. Now coming back to the case in hand, the landlady had transferred her interest by way of sale to the two brothers, Anwar Hussain and Manwar Hussain. Then it appears that all the interest as well as the title over the property has been devolved upon the transferee of the lessee. There is no rent agreement which is contrary to the transfer of interest of the lessor to third party. The petitioners have lost his interest and title over the suit property. In such facts and circumstances, the transferee of lessor is the necessary party. My lord,
Nothing has been stated
Yes.
about election.
what is the implication of section 109 and what is Ambika Prasad? It says that even in the absence of atonement, he becomes landlord, but he has to come in the court. He is not there. And this case doesn't relate to atonement, my lord. Not a single letter has been sent by the purchaser that I have purchased and I have
No,
become your
suppose
landlord.
by operation of law, the new purchaser becomes landlord. After the day property is transferred,
My lord,
still can you choose to elect
my lord.
to whom to make
So far
liable?
restoration is concerned, it is my choice, my lord,
Even-
because during the pendency of the suit, the transfer was carried out. Number one. Number two, my lord, he can file an suit against me that you are tenant, and first he will have to intimate by sending a letter, or he will have to intimate through court that I am the landlord. Now you start paying to me.
No, that is not question before us in the second CRP. Second CRP,
So I am replying to your lordship query, my lord, which is not the subject matter,
no, my query is in the second CRP.
my lord.
The suit filed by you was for restoration. In the second, the
My
suit
lord.
filed by you
My
was for
lord.
restoration,
Restoration of the property. in
restoration
its
of the property
Original form, yes.
against the original landlord.
Fine.
The landlady died.
Right,
Her legal heirs were substituted. During the pendency of the suit, the property was alienated to Manwar and Anwar Hussain,
fine.
who by operation of law, without any atonement on your part, becomes owner
Fine.
from the date of the purchase. Now, once till date, the property has not yet been restored. Now they have become owner. Now my query is, can you still choose to elect whom to make liable for
Fine.
restoration?
I have both the choices, my lord. I can ask for impediment and I can continue with the suit, not only against the original landlord, but also against the purchaser. But so long I don't decide, my lord, I cannot be imposed because the law protects me. That is my humble
Election.
submission.
Okay.
Election is upon me. And
And on that,
nowhere there is any
on that aspect, impugn order is silent,
silent. Though it referred to section 109
but it does not speak anything about election
about
by.
its implication, or yes, my lord, about election by the lessee.
Okay.
Now, my lord, before further proceeding, may I take your lordship to injunction order and how it can impact the impugned order so far my suit is concerned.
Yes.
My lord, page 114, the order of injunction, annexure 40. My lord, the relevant portion is at page 117. The connected part is in the middle portion, my lord. May I read from the fourth line? The prime concern,
Yes,
fifth line, my lord.
yes,
The prime concern of this court at this moment is the preservation of the disputed land till final adjudication of the title suit. Preservation of the land, my lord. Hence,
yes.
for the purpose as stated above, I am of the view that certain order must be passed by the instant court so that the ends of justice is served and there is no further opportunity of creation of multiplicity of suits and proceedings. Hence, taking recourse to power bestowed upon this court under section 151 of the Code of Civil Procedure, it is ordered that the status quo be maintained over the disputed premises, which is subject matter of this proceeding. This order of status quo in encompassing only regarding peaceful occupation against law by any party to this proceeding. This order of status quo is effective from today till final disposal of the instant proceeding. Now, my lord, status quo is the state which exists on that day. And in the meanwhile, when you alienate, the possession is delivered to someone else.
What is the date of injunction order?
4th of August 2011. And this was never challenged, my lord.
And no leave was obtained for
Even no
executing
information
chief.
was conveyed. Leave is second part, my lord. At least information. That information for the first time was given only in 2022. The sale carried out in 26th of April 2016.
Okay.
Now, what is its implication? Your lordship has already found that in the impugned order, there was a reference that an order of injunction was there. Now, what was its implication so far the sale is concerned? And what is the legal status of the purchaser? That was never considered. That part is totally silent. Now, may I take your lordship to two judgments?
No, but you are not challenging the sale deed. Your concern is
I
for
don't need-
renovation of your
My lord,
suit
I
property.
don't need challenge. The Honorable Supreme Court says the sale, if it is in the teeth of an order of injunction, is illegal, null and void. If it is so, my lord, because the court cannot remain silent spectator saying, yes, my order has been violated and I am not concerned since you are not objecting. Why I should object, my lord, when I can point out before the learned trial court, your order is this.
No,
And this is
you
what
are,
has,
you're not concerned with that relief.
I am
Even if
concerned, my lord. My,
you are concerned with restoration only.
I
You have
am
already chosen to elect
the
to
lesser.
make
the-
the original landlady liable. And to that extent, law protects you. Then where is the necessity? And you have not,
My lord, the law says when the court comes to know that its order has been flouted and apparently it has been flouted, I may not approach the court. Court will take its own action. What is this? Court will definitely ask.
yes,
And the seller, my lord. I am first relying on 2013 code. There are two judgments, my lord, I am providing simultaneously, both by the Honorable Supreme Court. The first judgment, my lord, is 2013, volume 4, AJR 653.
AJ,
R. Jehal Tati versus Nageshwar Singh.
error.
My lord, there are so many things to be spoken. Kindly come to paragraph 11. This is again based on Vidur Impex judgment, my lord, the highlighted portion. these transactions, the underlying portions, were in clear violation of the order of injunction passed by the so and so High Court, which had restrained respondent number 2 from alienating the suit property or creating third-party interest. To put it differently, the agreements for sale and the sale deed executed by respondent number so and so did not have any legal sanctity. Para 13, we may also notice section 23 of the Indian Contract Act, which lays down that the consideration or object of an agreement is lawful unless it is forbidden by law or is of such a nature that if permitted, it would defeat the provisions of any law or is fraudulent or involves or implies injury to the person or property of another, or the court regards it as immoral or opposed to public policy. In each of these cases, the consideration or object of an agreement is unlawful, and every agreement executed with such an object or consideration which is unlawful is void. Since the sale deed was executed in favor of respondent number 2 in teeth of the order of injunction passed by the trial court, the same appears to be unlawful. This is ancillary mark. The sale deed itself was not under challenge, my lord. But the court, when it found that it was in the teeth of the order of injunction, then it said it is unlawful. The second judgment, my lord, Surjit Singh and others versus Harbans Singh, EIR 1996 SC, page 135, para 4. As said before, the assignment is by means of a registered deed. The assignment had taken place after the passing of the preliminary decree in which Pritam Singh has been allotted 1/3 share. His right to property to that extent stood established. A decree relating to immovable property worth more than 100 rupees, if being assigned, was required to be registered. That has instantly been done. It is per se property, for it relates to immovable property involved in the suit. It clearly and squarely fell within the ambit of restrained order. In sum, it did not make any appreciable difference whether the property per se had been alienated or a decree pertaining to that property. In defiance of restrained order, the alienation assignment was made. If we were to let it go as such, it would defeat the ends of justice and the prevalent public policy. When the court intends a particular state of affairs to exist, while it is in session of a lease, that state of affairs is not only required to be maintained, but it is presumed to exist till the court orders otherwise. The court in these circumstances has the duty, as also the right, to treat the alienation assignment as having not taken place at all for its purposes. Once that is so, Pritam Singh and so, thereafter, my lord, the Honorable Apex Court again starts speaking about the concerned case. Next, in the same paragraph, my lord, therefore, the assignees, respondents could not have been impleaded by the trial court as parties to the suit in disobedience of its order. Now, my lord, another implication which I highlighted before the trial court, that if you allow the purchasers to appear, you are actually validating the sale deed, number one. Number two, you are ignoring your own order of restraint. Now, what will be the mental status of a plaintiff who is before you? He is showing that there is an order of injunction, and this person who cannot plead ignorance, either the seller or the purchaser, both are hand in gloves. They are before this court, not the purchaser, but ultimately the seller is there saying that you kindly implead him. You are asking me to implead him, the assignee. Thereby, you are validating the sale deed.
No, it can be, the order was of status quo. Status quo.
Status quo in regard to what?
In regard
To
to your
maintain-
in regard to your relationship towards the other side. You remain tenant.
My lord.
There will be no eviction.
So possession was, my lord, then I leave it. I will challenge it in another way.
Yes, you may tell, because you
Okay.
have a case.
Then-
If you press for that doctrine of election,
My lord, I leave it. I will challenge it in another way. lord,
otherwise,
May I show some other judgments so far my election is concerned, my lord. That part.
One judgment will be suffice, any judgment.
I am not so miser, my lord, I will place 3.
It will burden me unnecessarily. Because if you cite, I have to reflect it.
My lord,
Otherwise, the statute is itself appears to be clear.
2 judgments, my lord, kindly give me that liberty. I am referring to 2004 SCR supplementary 5. Kindly come to page 1086, my lord.
Yes.
Normally, last part, my lord. Page 1086, last part, H. Normally, in a case covered by order 22, rule 10. Why I am referring order 22, my lord? Order 22, rule 10 was ultimately taken recourse to by learned trial court. That part I did not refer, my lord. Civil procedure where rights are derived by an assignee or a successor in interest pending a litigation. It is for that.
Which page you are reading?
1086, last line, my lord.
Yes.
Normally, in a case covered by order 22, rule 10 of the Code of Civil Procedure, where rights are derived by an assignee or a successor in interest pending a litigation, it is for that assignee or transferee to come on record if it so chooses and to defend the suit. It is equally open to assignee to trust its assigner to defend the suit properly. Now, my lord, the purchaser, let us assume they are silent and they believe in the capability of the assigner, that is the seller. That is why they have chosen to remain silent. So what it says, it is equally open to the assignee to trust its assigner to defend the suit properly, but with the consequence that any decree against the assigner will be binding on it and would be enforceable against it. I cannot stop the assignee, my lord, or the purchaser from coming
Okay,
on record.
then in your suit, even if decree is obtained against the previous landlord lady, will it be binding on the present purchaser?
Yes, my lord, because they have the option to come on record, which they have elected not to. So far, my 109 protection is concerned, my lord, it protects me. But the day they make an application, I cannot oppose them. That is the law, my lord. If they come on, they want to bring themselves on record by virtue of order 22, rule 10, then I will have to happily allow them to enter, my lord. Which they have not chosen the path, my lord, till this. One more judgment, my lord. There are others, but I am not raising. 2015, my lord, SC 3747. That is Sardamma versus Muhammad Pyare Ramjan. Para 5, my lord. The highlighted portion, my lord, under order 22, rule 10, it is at the option of the assignee to move an application for impleadment. Para 5.
Yes.
Para 6. A bare reading of provision of order 22, rule 10 makes it clear that the legislature has not envisaged the penalty of dismissal of the suit or appeal on account of failure of the assignee to move an application for impleadment and to continue the proceeding. In this case, my lord, what had happened, the plaintiff, she filed a suit against defendant saying that I have the right title and therefore the defendant should be evicted. Her suit was dismissed. She filed an appeal, the plaintiff, my lord. During the course of the pendency of the plaintiff, she transferred her property to her daughter. And immediately thereafter, the daughter transferred the property to someone else by way of a deed of sale. When this fact was brought to the notice of the appellate court, they immediately dismissed the appeal, saying that since you have transferred, you have lost the interest. Then in that event, what is the observation of the Honorable Supreme Court? A bare reading of the provision of order 22, rule 10 makes it clear that legislature has not envisaged the penalty of dismissal of the suit or appeal on account of failure of the assignee to move an application for impleadment and to continue the proceeding. Thus, there cannot be dismissal of the suit or appeal, as the case may be, on account of failure of assignee to file an application to continue the proceeding. It would be open to assigner to continue the proceeding, notwithstanding the fact that he ceased to have any interest in the subject matter of dispute. He can continue the proceeding for the benefit of assignee. Now, in my case, my lord, I want to continue, and it is the option of the assigner to protect the interest of assignee also by continuing with the suit, or they have the liberty, my lord, not to appear from the next day. It is their choice. And so far assignee is concerned, they have all the freedom to knock the door of the honorable court, my lord, the court below. That's
Okay. I'm reserving. Heard. Mr. Both item separate orders. Heard Mr. S.K. Singh, learned senior counsel assisted by Mr. A. Ganguly, learned counsel for the petitioner. None has appeared for the respondent. Hearing concluded, judgment reserved.
My lord, may I point out, so for the second case, 153-24 is concerned, while submitting the original CRP, there was an error so far filing of exhibit annexer 9, 12 and 13 is concerned, which we corrected by way of additional affidavit with the leave of the honorable court. 9, 12 and 13. Subsequently corrected, my lord.
What was the error?
So far, annexer 9, 12 and 13 was concerned, my lord. We submitted it from the previous one. There was a little difference, my lord, in the application. Very minor difference, but ultimately we have to file the correct version, which we filed.
Okay, okay.
That is not going to have any impact, but at least I should inform the honorable court, and we have filed.
Okay.
Obliged.
Here in this case, we have taken steps by publishing of newspaper lordship upon as per number 3 and 4, but we need 1 week time to file the affidavit.
Taking steps through Dasti mode,
Paper publications.
paper publication.
And this appeal was already admitted lordship on 12/8/22 itself.
Okay, heard Mr.
SP sir.
S.P. Sharma, learned counsel for the appellant. Also heard Mr. D. Mondal, learned counsel for respondent number 1 and 2. Paper publication in respect of which
Respondent number 3 and 4.
learned counsel for the petitioner. Where is the order that you can take notice through paper publication?
Lordship ordered.
Order was passed in IA Civil 14/50/25.
Not in the main. IA Putul, IA number
14/50/25.
Lordship had ordered it 16/10/25 lordship. Were directed to take steps by newspaper.
16/10/25, in which case?
IA lordship.
IA number
Your lordship, the IA number 14/50/25, order
27/8.
27/8/25.
This IA
La-
relates to what?
Appeal. Your lordship, I have filed this IA for vacation of stay order. The stay order was passed
So
without directing.
you were directed to take steps.
No,
No, no.
we were there.
Because we had a-
But this order has been passed in IA only.
This order ought to have been passed in MSc appeal, but since that IA was listed on that day, so the order was passed on.
The publication had already been done, Lordship. Only affidavit request.
No, you are not understanding. If in IA, direction is given to the applicant to take steps, and the applicant is the respondent in the main suit, what would be the implication?
No, your lordship, here therefore the insurance company shall take steps for publishing notice. There specifically, this order is relating to the appeal, but it was passed in the IA, wrongly passed in the IA. Since they are challenging the liability, the presence of owner driver is required.
Likho. Learned counsel for both the parties have submitted that by order dated 27/8/2025, a coordinate bench of this court by order dated so and so passed in IA civil 1 I within bracket C 1450/2025. A coordinate bench of this court had directed the insurance company to take steps for issuance of notice upon respondent number 3 and 4 through paper publication in vernacular newspaper showing date of appearance as 16/10/2025, that is today. Learned counsel for both sides have submitted that the said order ought to have been passed in the MSc appeal number, the instant MSc appeal number 469/2022. And it may be treated to have been passed in the MSc appeal. Learned counsel for the
Your lordship, another thing, in the IA, I have not made owner driver as party. I have made only the insurance company as party.
learned counsel for the applicant of the IA number 145025/ respondent number 1 and 2, Mr. D. Mondal has submitted that in the said IA was filed by the
Claimants.
respondent
Claimants
number
respond.
1 and 2 claimant praying for vacation of the stay order. And in that case, respondent number 3 and 4 were not made parties. Therefore, he submits that if the order is treated to be passed in the main case, he does not have any objection. On the other hand, learned counsel for the appellant has submitted that in pursuant to the aforesaid order dated 27/8/2025, the appellant has taken steps for publication of notice through in the vernacular newspaper as directed by the coordinate bench of this court. And he seeks a week's time, 1 week's time to file an affidavit in compliance in that regard. The prayer is allowed. Let this matter be listed after.
Lordship,
And Lordship, a reminder for LCMA kindly be sent. Lordship.
in the last week of November, your lordship.
In the last week of November on a date to be fixed by registry. It also appears that the records of the concerned MSc case have not yet been received. Registry to issue a reminder for the same. Into main case or main MSc case of in IA, what will happen?
I will be considered after.
After receipt of the LCA.
Stop. I heard Mr. D. Mandal, learned counsel for the applicant, and Mr. S. P. Sharma appearing for the insurance company respondent. In the main case, since the records of the concerned MSC case has been called for and same has not been received, this IA would be considered only after receipt of the
Trial court record.
trial court records, list accordingly in the last week of November, along with MSC appeal number 2469/2020.
Obliged.
Highly obliged.
May I please your lordship? Your lordship, in IA 1655 of 2024. If the
Yes.
lordship, if the lordship comes to the office note dated 12/11/2024. It is written that according to that notice were issued, we have taken the steps and the answer notice has been received back.
This IA is for what purpose?
It's for condemnation of delay.
No such persons. Then what is to be done?
In their official it is written that no such person in the address, in that address, and that address was provided by our friend. So I request your lordship to direct him to furnish the proper address so that we can take the steps.
My lord, the respondent, my lord, is their own, my lord, niece, my lord. So address not known by them, my lord, is absolutely, my lord, unbelievable. Their brother and sister, and they did not know the address.
Your lordship, they are the rustic villagers, so they are.
They are the
Rustic villagers,
Rustic
I mean,
villagers.
villagers
But-
also, and they are quite illiterate, and they are, I have not, we have not received that instruction from them also.
You seek instruction,
I will-
you get the proper address.
Yes.
Mr. What is your name?
R. Borua.
R. Barwa, learned counsel for the applicant. Also heard Mr. R. Ali, learned counsel for whom you are representing.
My lord, 1 and 2, my lord.
This condonation of delay is for what purpose?
For setting aside abatement and substitution of legal years,
Of respondent number 3.
lordship.
Okay. You are appearing for respondent number 1 and
On 2, my lord.
learned Mr. R. Ali, learned counsel for respondent number 2. On perusal of the office note dated 12/11/2024, it appears that the notices sent to respondent number 3A, 3B, 3C, and 3D have written with postal endorsement within inverted comma, no such person in the address, comma, RTS, inverted comma, close. In learned counsel for the applicant submits that he may be allowed some time to get proper instructions regarding the proper address of the aforesaid respondent and to take fresh steps after ascertaining the proper address of the said respondent. The prayer is allowed. Let this case be listed. No, the prayer is allowed. The applicant shall ascertain the correct address of the aforesaid respondent and thereafter takes fresh steps for issuance of notice upon the said respondent by registered post with AD as well as by usual mode. Returnable after 6 weeks. You take steps within 15 days. Take steps within 15 days, returnable after 6 weeks. List accordingly.
Item 9, obliged lordship.
Kindly see the last one. And you can have the respond number 1 to 8 and 18 to 22.
Yes.
Lordship, I'm for the applicant lordship. I filed an IA to substitute the legal care of respondent number 2 lordship, but that I was found defective lordship. So I need 1 week time, so I may be allowed
In
to.
the year 2023, my lord, they have filed one substitute petition, my lord.
When have you filed substitution?
Lordship, 26, 2023 lordship.
23.
Lordship.
And for last 3 years, you have not.
Rectified, my lord.
Then how to substitute the legal heirs of respondent number 2?
Two lordship. And in that petition lordship, my friend pointed out that one of the legal care is left out to made party lordship. So only 1 week time. Lord.
This appeal has already abated against that said said respondent by operation of law.
No limitation, my lord. After limitation, my lord, they have filed a substitute petition, my lord.
And that is not before this court.
Lordship. And they stated that they have delivered to my lord and they willfully, my lord, delay the matter, my lord.
A last chance may be given lordship. So that I can. On the last occasion, I was not present lordship, so.
Last chance for what? For what?
To substitute the legal heirs of respondent number 2 lordship.
Heard Mr. What is your name?
And hot lordship.
Heard Mr. M. Hock, learned counsel for the appellant. Also heard Mr. A. Mubarak, learned counsel for respondent number 1 to 8 and 18 to 22. Learned counsel for the appellant has submitted that the appellant, on death of respondent number 2, has taken steps for substitution of the legal heir of respondent number 2 by filing appropriate application in the year 2023.
Okay.
However, same has been found to be defective. And therefore, same is not listed before this court. He submits that he may be granted 1 week time to do the needful for substituting the legal heirs of respondent number 2. Though, stop, it appears, when the respondent number 2 died,
2/3/2023, my lord.
when
3/2/2023.
it is submitted at bar that respondent number 2 had expired on 3/2/2023, and therefore it appears that by operation of law, this appeal has already been abated against the said respondent. Otherwise, the case is ready for hearing. Stop. Considering entire aspect, one more chance is granted to the appellant to take appropriate steps for substitution of the legal heirs of respondent number 2 before the next date fixed. Stop. Let this appeal be case be listed again in orders column on 3rd of November.
Obliged, Lord.
May I please your lordship, as per the office note dated 13/10/2025, unserved notice regarding respond number 3 and 4. As per the notice, respond number 3 out of station for a long time and respond number 4 refused to take the notice.
Now what is to be done?
We will take steps on respond number 3.
Respondent number
3. 4 refused to take.
and respondent number 4, what has happened?
Respond number 4 refused to take.
Refused to take.
Refuse. Actually, as per the office note, it's refuse. Return to section.
Which office note you are referring to? Office note dated
13/10/2025.
concern. Some return notice. Notice return हुई miscellaneous file এখন থাকে না। Who is respondent number 4?
Respond number 4 Nivedita Das.
Who refused? Respondent number 4.
4.
Refused. Okay. Heard. Mr. What is your name?
R.K. Mohanta on behalf of P. Bodlo.
Heard Mr. R.K. Mohanta, learned counsel for the appellant. Also heard Ms. K. Sharma, appearing for
Respondent number 1 and 2, your lordship.
respondent number 1 and 2. On perusal of the office note dated 13/10/25, it appears that the unserved notices issued, unserved notices, the notices issued to respondent number 3 and 4 have been returned back without service. Stop. However, it also appears that the respondent number 4 has refused to accept the notice, and an endorsement to that effect is found on the envelope of the registered post with AD sent to the said respondent. Therefore, this court, therefore it is held that the notices are deemed notices issued to respondent number 4, which she refuse to accept is deemed to be duly served on the said respondent. As regard respondent number 3 is concerned, the appellant shall take fresh steps for issuance of notice on the said respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Please.
Yeah, please, Your Lordship. Well, this case should have been listed for hearing, my lord.
Yes.
But last occasion it was listed for hearing, but today it has come under order column. So may I pray, my lord?
It is ready for hearing,
Yes, yes, my lord.
both sides.
Yes. TCL also has come, my lord, and all the parties have been represented.
Heard Mr. J. I. Borgnia, learned counsel for the appellant. Also heard Mr. B. Dutta, learned senior counsel assisted by Ms. S. Dekar, learned counsel for the respondent. It is submitted at bar that this appeal is ready for hearing. And stop. Once I have perused the records, since this case is ready for hearing, list this matter for hearing.
It's a fixed date, my lord.
That date may be fixed, my lord.
Otherwise, it's difficult for me also to accommodate my safety. 17 or 18, my lord.
Suggested it.
17 or 18.
November.
18. Hearing.
18th November.
18.
List this matter.
18, my lord.
18 November.
Grateful, my lord.
I think 13.
Okay, I'm assuming the order already done it. Mr. Johar, your lordship, which is at page 42, your lordship.
This case, lordship, last occasion record was called for lordship.
Record has.
And the record received lordship. So lordship, may I pray lordship kindly fix a date for final hearing because lordship, 1,000 maintenance was granted to the wife lordship. I am appealing for the wife lordship. So last 1 year lordship, nothing has been paid to me lordship. So that's why last occasion record was called for. So, lordship,
Okay, okay.
next week, any date lordship, because last 1 year I have not received anything lordship. In spite of, there is no stay order lordship.
This is item number
13 years.
heard. You are Dr. R.
Sharma.
Sharma. R. Sharma, learned counsel for the petitioner. Also heard Ms. P. Bhattacharya, learned counsel for the respondent. It appears that the trial court record which was called for has been received. So it is submitted at bar that this case may be fixed for final hearing. Stop. Let this case be listed for hearing.
23rd if possible lordship. Because she is unemployed lordship. Wife,
Hearing on 23rd of
October.
October.
Obliged lordship.
14.
Lordship, there are 3 applications. Immediate petition followed by setting aside abatement and substitution petition filed by the appellants. Here in this case, the plaintiff, original plaintiff died on 5/2/2022 during the period of extended period of this one, COVID. Lordship, my submission
How
is that
much delay is there?
there are 759 days, 96 days.
You
I
are,
have not filed any objections.
you are opposing or
Matter may be
Proceed.
fixed for hearing.
heard Mr. B. K. Bhagavati, learned counsel for the applicant. Also heard Mr. What is your name?
Muhammad A. Rahman on behalf of A.W. Amani.
Appearing for
Respondent number one, Your
Also heard Mohammed K.
Rahman.
A. Rahman, learned counsel for the sole respondent was there.
Yes, Your
No.
Lordship.
Respondent number one, as well as Mr. Who is the pay? What is your name? Also heard Mr. N. Sarania appearing for respondent number 4, as well as Mr. E.R. Gogoi appearing for respondent number 2 and 3. This application under Section 5 of the Limitation Act 1963 has been filed by the applicants praying for condoning the delay of 796 days in filing appropriate application for setting aside abatement, as well as for substituting the legal heirs of respondent number 1 beyond the prescribed period of limitation. The learned counsel for the applicant has submitted that the grounds for approaching this court belatedly after a gap of 796 days has been stated by the petitioners in
There are 4,
para 4,
5,
4, 5,
6, 7, 8,
4, 5, 6, 7, 8, and 8 of the application for condonation of delay. The learned counsel, no, you are not opposing. Learned counsel for the respondents, considering the grounds shown by the applicant, do not oppose the prayer for condonation of the delay. Stop. This court, accordingly, considering the ground shown by the applicant in the application to be sufficient grounds which prevented the applicants from approaching this court within the prescribed period of limitation, as well as the fact that the application has not been opposed by the respondents, allows the same and condone the delay of 796 days in filing the application for setting aside abatement, as well as substitution of the legal heirs of the respondent number 1. This interlocutory application is accordingly disposed of. Setting aside abatement,
4, that is 4080.
4080. Setting aside abatement is 4083.
4083.
Agora é tudo Deus. Thank you. Heard same parties likhebo. This application under Order 22, Rule 9 of the Code of Civil Procedure has been filed by the applicants praying for setting aside abatement of the connected RSA number 66/2018 on the death of respondent number 1 on 5/2/2022. Stop. Though there was a delay in filing the instant application, the said delay has been condoned by this court by order dated 16/10/2025, passed in IN number 4082/2025. The applicant has shown the cause for setting aside of the abatement in the application filed by them. The prayer is not opposed to by the Learned Counsel for the respondent says, hence same is allowed. Accordingly, the abatement of the appeal on the death of respondent number 1 is hereby set aside, and this interlocutory application is allowed. Next, 4080, parties যাকে লিখিব। This application under our Order 22 Rule 4 of the Code of Civil Procedure has been filed by the applicants for substituting the legal heirs of respondent number 1. Respondent number 1, namely Ramji Shah, who expired on 5/2/2022. Though this appeal was abated on his death, however, the abatement has been set aside by this court by order dated 16/10/2025, passed in IN number 4083/2025. Who are the heirs? Where are the names?
And then sir, at page 4. 1A, Labakumar Shah, 1B, Ashok Kumar Shah.
Stop. The applicant has prayed for substituting the names of Labo Kumar Shah and Ashok Kumar Shah, who are the sons of deceased respondent, late Ramji Kumar Shah. Stop. The said prayer is not opposed to by the respondent side. Hence, same is allowed. The names of Labo Kumar Shah and Ashok Kumar Shah shall be substituted as respondent number 1 within bracket A and 1 within bracket B in place of deceased respondent Ramji Kumar Shah. The appellant shall submit an amended memo of appeal showing the names of the substituted defendant therein. Lead registry is directed to list the connected appeal after 2 weeks.
Lord, this is an application under section 301 of the Indian Succession Act for change of executor, Mother, of the will. And this was supposed to come for admission, Mother. This is the second time they were supposed to file an affidavit.
Admission hearing.
Yes, my lord. Already service is completed.
Oh, no question.
Yes, Mr.
May I
Vishwa.
please- well, we both are for 2 and 3, but it is a dispute between the brothers regarding the execution of the will, my lord. So, my lord, we wanted to, some well-wisher has come up to settle the dispute between the brothers. Sir.
No, I am not instructed.
Yes, you are not instructed, but I have been instructed. So can I pray for little accommodation for 2 weeks, my lord, at least?
No, my lord, I have some
it is-
urgency, my lord, because the will, the properties, my lord, here still, he is managing, my lord. The
Because I
respondent one is.
by virtue of the order of the court.
To whom it has been
Property has been
bequeathed
bequeathed against me, my lord. I'm
in
one of
your
the son.
favor.
I'm one of the son, my lord, of the deceased. So.
But if there is a possibility of amicable settlement between brothers,
So that was, I am not instructed regarding that, my lord.
You are not instructed. My client told me, that's why I'm
okay,
saying.
we are fixing this matter for admission hearing
On
after
24th,
after 2 weeks.
on 24th,
Next
because
month,
they have
next
taken
month,
time, my
any
lord.
date for next month.
24th will be difficulty on our part.
First week of this November, my lord. Any date.
Yes.
November is the-
Heard Mr. B.K. Bhagavati.
Road.
Sorry. This is item number
15.
R. Chakravarti, learned counsel for the appellant. Also heard Mr. S.C. Bishwas, learned counsel for respondent number 1, 2, and 3.
First one month. Yes, 1, 2, 3.
1, 2, and 3. Stop. Learned counsel for the respondent has submitted that there is a possibility. Learned counsel for the petitioner appellant submitted that this case has been wrongly listed under order column and it ought to have been listed for admission hearing column. And he prays for listing it in the next week, showing some urgency. On the other hand, learned counsel for the respondent has submitted that the petitioner, the appellant and the respondent are brothers in relationship and there is a possibility of amicable settlement as some well-wishers have come forward to
That will be.
settle the matter amicably between the brothers. And therefore, prays for listing this matter after 2 weeks. Though learned counsel for appellant showed his ignorance and absence of any instructions regarding any such amicable settlement. However, considering the submission of learned counsel for the respondent, let this matter be listed in the first week of November on a date to be fixed by registry in the admission hearing column.
Well, a date will be fixed.
First week of November,
Yes,
the
possible.
registry will fix the date.
Well, even if, my lord, the limitation is already over, my lord, to file a probate proceeding, my lord.
It is your
So-
matter.
So what
That's why, my
negotiation
lord.
they would come to, my lord, that is not very
We'll
clear.
take it up in the first week.
All right.
Item number. Yes.
Yes, my lordship.
My lord, records were called for, records have not come.
Yes.
8:10, my lord.
Heard Miss. What is her name?
Borsa Bordlu.
What is her name?
Borsa Bora Bordlu. BB Bordlu.
B. Bora Borgohain.
Lordship, AM Alamgir, I have on the above.
AM Alam
Gir.
Gir, appearing for the appellant. Also heard Mr.
A. Iqbal,
A. Iqbal, appearing for respondent number 1, 2,
11, 12, 13, and respondent number 2
1, 1, 1, 2, 1, 3,
and 2.
and respondent number 2. It appears from the office note that records of the trial court which were requisitioned have not yet been received. Issue reminder for the same. Registry to take steps for issuing the reminder for the records. Let this matter be listed in the second week of November on a date to be fixed by.
Deeply applied.
17. My lord, in this case, I'm appearing on behalf of the respondents, my lord. Since the record was called for, my lord. Probably this record has come, my lord. And my lord, the lordship may fix the matter
for admission. In the meantime, we will file the objection since the petition is under Article 227. So we have to file the objection.
Okay, heard Mr. S. Chauhan, learned counsel for the petitioner. Also heard Mr. B. Chetri, learned counsel for sole respondent,
Yes, sir.
sole respondent, who prays for allowing the petitioner to, allowing the respondent to file a written objection. It also appears that the records of the trial court have been received. Stop. Let this matter be listed in for admission here, for admission in the second week of November on a date to be fixed by registry.
Meanwhile, we will file the objection.
Yes. Outline the meanwhile, the respondent may file written objection as prayed for by them.
Bless you.
Yes.
This service is already been completed. I have filed a reply regarding service, justice service.
You have to file an affidavit. You have filed.
On the
Justice service upon whom
respondent number 1.
it has been served.
Yes. I
Have
filed
you
affidavit.
filed an affidavit?
Yes, affidavit on file. 13/10/2025. At page 135.
Lordship, I am appealing for respondent number 2.
Two.
So I have filed my affidavit in opposition, but on 14th, but same is not on record. So let it come on record, my lord.
Justice service. Have you obtained the signatures of respondent number 1?
Yes.
Where?
Yes. Alexa, page 138. Left corner, bottom of the left. At page Annexa 1, at page 138.
What is the name?
19/2025.
What is the name? Imran Hussain.
Yes.
Heard Mr. L. K. Bora, learned counsel for the petitioner. Also heard Mr. M. Datta, learned counsel for respondent number 2. Stop. Learned counsel for the petitioner has submitted that the petitioner has filed an affidavit in compliance regarding service of notice upon respondent number 1 through Dasti mode. On perusal of the affidavit, it appears that same is accompanied by the notice to respondent number 1, and on the said notice, the signatures of respondent number 1 appears to have been put. So in view of the above, the notices issued to respondent number 1 is held to be duly served. Stop. Learned counsel for respondent number 2 has submitted that though respondent number 2 has filed a written objection in this case, same is not yet tagged with the case record. The registry is directed to place the written objection filed by respondent number 2 along with this record and list this matter in the second week of November.
My lord, may fix a date, my lord. early date, my lord, because I am the plaintiff, my lord. I am
In the
suffering.
last week of October, on a date to be fixed by registrar.
My lord, I just want to point out one more thing, my lord. This, my lord, in the course title, my lord, my name has been wrongly mentioned, my lord, Benjir Hussain. I am Benjir Begum. That's why my Wakalatnama is also not accepting, my lord. Let them pay.
I may be allowed to correct by hand.
Not by hand, you file a learned counsel for the petitioner submits that due to inadvertence, the name of respondent number two has been wrongly mentioned in the cause title of the instant revision petition, and he seeks leave of this court to file an amended cause title showing the correct, what is your name?
Benjir Begum.
Yes, showing the corrected name of the respondent number two. The prayer is allowed. The petitioner shall submit the corrected cause title before the next date fixed.
Deeply your lordship. My lord, please, my lord, I seek an indulgence, my lord. If item number, what my senior is there, if item number, my lord, 19 is, if my lord wants to take it up. We have no objection.
During lunch?
My lord,
No, when do you want to take it?
my lord, after lunch, my lord, 2 p.m. my lord can be. I'll submit.
It will come at 2 only, lordship, because next is our case.
He may want me to skip my lunch.
Come on, lord, come on.
This matter may be taken up first week of the November.
Okay, earlier matter first week of November.
Yes. Let them point out, we have already made our submission, my lord. If there is anything, they come.
You can make brief submission
My lordship,
to refresh.
one suit was filed. One suit was filed challenging the holding of an AGM dated 21st of September 2025. Lordship, kindly have a look at the prayer. This is very important. At page 21, the plaint starts and prayer is page 43. No, 45, my lord. Page 44. And declaration was sought for, declared that the annual general meeting of the defendant society scheduled on 21st of September 2025, together with its agenda, is illegal, unconstitutional, and contrary to law. And also an injunction in the form of the mandatory restraining the defendants of society such and such from holding the said AGM. The award cost of the suit such and such. My first submission is that is entire concern of the suit is the holding of AGM of 21st. And what the grievances is, Lordship will find at para 4 of the plate. As page 24.
Yes.
6-7 line from the bottom.
Yes.
It is a settled requirement under the rules of the society that before convening any annual general meeting, the accounts of the society pertaining to the immediate previous financial year are required to be duly finalized, circulated, and placed before the members for their consideration, such and such. However, to the best of knowledge of the plaintiff, the accounts of the last financial year 2024-25 had not been finalized and audited up to date. So therefore, the notice pertaining to holding of the meeting, that report was not finally placed. That was the grievance.
Now, on 19th of September, the Learned Trial Court rejected their injunction application.
Yes.
As page 46, the injunction order is annexed of the Learned Lower Court. The
Yes.
Learned Lower Court though finds a prima facie case, but the court has had a conclusive finding that there was no irreparable loss and injury. The Learned Court finds the facts remains, my lord, that this society having membership of 697. Out of that, this plaintiff alone has filed a suit. No grievances from the other in this litigation. This is number one. Number two is that the Learned Trial Court finds that even if the AGM is whole, then there would be no question of any irreparable loss, because it's a very logical conclusion that had he been any grievances, that can be ventilated in the meeting itself. Now that facts situation is now changed. Now, after the rejection of their injunction application, on the same day, on 19th itself, an appeal was filed. The affidavit was shown on the same day. I convey my thanks to the council of there in the Dibrugarh. They show apprehensive in mind that the injunction order would be refused. So therefore, the appeal was repealed, and that was filed with two applications. One application to crave a leave of the appellate court to admit the appeal without the certified copy of the impugned order. And the appeal memo annexed the plaint and injunction copy. And the Lordship is a long judicial career experience that it would be absolutely improbable, it's not procedural, any sanction to admit any appeal without the order impugned. And on next day, that is on 20th of September, an order was passed. That order was not annexed, my lord. I've just placed it before the honorable court. The two application was filed. One is to create the leave to file the appeal without certified copy. And another application was filed under order 41 rule 5.
For injunction.
For injunction, madam. It's absolutely strange perception, because Lordship is aware the order 41 rule 5 is relates to the power of the appellate court of state. They have filed the appeal without any application of order 39 rule 1 and 2. Another application was filed, that order 41 rule 5, and Learned Appellate Court fixed the matter on 24th of September for hearing of those both applications. And also to hear the maintainability of the caveat. Lordship will kindly just have a look at the last line, para 11 of that order I have just placed. For hearing of the petition number 5835, 5835 relates to the order 41 rule 5. And 5848, that relates to the leave to file without copy, and also an admissibility of the caveat. The date is very important, my lord. On 24th of 9, 2025, the declaratory decree so far the 21st of September, that has been done. So my respectful submission is that the suit become infructuous on the very day of 24th 9, 2025. Now on 24th 9, 2025, by the impugned order, without disposing of these two applications, the Learned Appellate Court grant a status quo order in respect of the status of the society, as well as the holding of the AGM, which was not prayed for in the suit. Apparently, it is a blanket order. The legal flaw is, which the appellate court committed a serious error and jurisdictional error, my lord, that without the prayer of permanent injunction and temporary injunction, the court having no jurisdiction to pass any order. I placed two judgments, already is also aware.
Otherwise, also the suit has become infructuous.
Infructuous. Now, what happened meanwhile, one fact I have to just to place before this honorable court. On 21st September, that is the day of holding the annual general meeting, Lordship is aware that on 19th September, there was an incident at Singapore and there is the unfortunate death of Jubin Garg. So thereafter, from 1909 to 2024 onwards, entire Assam, all the scheduled program of all organization, everything has been closed, suspended. So on 21st September 2025, keeping in mind that the prevailing situation, the meeting was adjourned and the next scheduled meeting was to be decided on 25th of September. Now on 24th of September, that is the day of hearing of both the petitions before the appellate court, the appellant has filed an application under Order 41, Rule 33. That relates to, Lordship is aware, the power of the appellate court. And saying that this meeting is now scheduled to on 25th of September. Now that meeting was also not held because of this legal complication. Now, at this stage, my lord, my only limited submission is that the suit become infructuous because they have not said anything beyond 21st of 9. That any meeting to be held on 21st or thereafter. So it is absolutely concerned, the subject matter is 21st 9. So 21st of 9, that's become, that date become, then lapsed. So entire suit become now infructuous. Now what we propose now, not only the leave of this court is required. Now you cannot hold or restrain us from holding the annual general meeting. Because our official term is going to be already expired on 26/9 of 2025. Now I have extended period of 6 months as per the rules to hold the election. After the completion, this is in the rules. The 6 months. So I have to hold the meeting. And the entire hospital is run by the society, my lord. So entire function of the hospital.
Now what do you propose?
Now I propose, my lord, to hold the meeting afresh by giving a 21 days notice. And also my auditor's report is now ready. Or who is there, they're having a grievance. 24-25 financial year audit report is ready. So that
21 days notice is required under which rule?
This is the general. I will. Roshi, first have a look at Rule 15.
Yes.
The annual general meeting. The B is important. The item of the agenda.
Your submission is that you will comply with the Rule 15. Rule 15.
Yes, I will comply with. We issue the fresh notice, my lord, including this. The Lordship will find B Roman 3, clause B Roman 3, which they're having a grievance. To receive, consider, and pass the audited accounts of the preceding official of the society. That is 24th meeting.
Okay.
So that we have ready, that we have placed.
Yes.
My lord, here in this case, the imprint order has been passed in the miss case. And what my learned senior friend has showed the prayer portion, my lord, that is in the title suit. Here I have a copy of this case, my lord. I am reading out the prayer, my lord. Under the aforesaid circumstances, it is prayed that your honor may be pleased to grant temporary injunction
No,
Questioning-
his submission is that we have not prayed for any permanent injunction.
In the main suit, you cannot say in the.
That is his submission. And otherwise also, your grievance was that without submitting audit report, the meeting is going to be held. Now they are ready to comply with it.
But my lord, their term, the term of their, that has already been elapsed, my lord. 3 years has elapsed. Lordship may kindly see at,
No. That is not the issue. Issue is you were aggrieved by holding of meeting,
yes, my lord.
annual general meeting, without following rules, without submission of the audit
Yes, my
report of the previous year,
Yes, my lord.
which they have prepared. And they are ready to comply with
My lord,
this
My
is
lord,
one
I-
aspect. And other aspect is your suit was very specific in respect of the,
Lordship, they have extended the time, my lord, that has come in paper, my lord. Kindly have it.
That I have already submitted, 25th, that was also not,
that day also has lapsed.
that also lapsed.
Okay.
May I please, Your Lordship? Your Lordship, that the opposite parties, respondents have challenged the LS AGM, which was first scheduled on 21st/9/2025, as it was not called as per the provisions of the bylaws of the society. The bylaws under clause 15 of the bylaws.
Okay.
It's-
Now they are ready to comply.
They have already lost their term. Their term has already been over.
That
So
is
if
not
any,
subject matter of the suit.
if any, we have already approached to the Registrar of Society. Let the Registrar of Society to act, exercising its power by forming a ad hoc committee. Ad hoc committee will do. They will do whatever if has to be done.
All
Their term has
unnecessary
already been-
submission, my lord, kindly have a look at clause 16. Kindly have a look. One should not mislead this honorable court, my lord. Kindly have a look at clause 16.
Exhibit.
Clause 16(6), lordship will kindly have a look. Their act is only disturbing the entire law. 6, lordship will have.
Yes.
The committee to be elected once in every 3 official years in the AGM shall hold office till the election of the next committee subject to rule 23. Now, lordship kindly have a look at 23. Lordship, 23. 23(2), my lord.
Yes.
The election of the committee is not, if not held within 6 months after the expiry of his term of the 3 official years. Then only ad hoc committee, extraordinary general meeting, all that.
That tenure is not over.
Not over. And they have wrote a letter to register everybody, this person, this plaintiff. Out of 697, my lord. Only one person disturbing everything. What is the locus standi, my lord?
Okay, let him submit.
Your Lordship,
I'm the chartered accountant.
I am the chartered accountant. I am the expert of this area.
I was the-
I know the consequences if these lacunas and illegalities is allowed to be happen. And I, being a bona fide member, I have every right to challenge.
What is the illegality?
Your Honor, as per the clause 15, as per the clause 15 of the Constitution, kindly, Your Honor, in page 12 of the
Yes.
society.
Yes.
Amount. General meeting, annual general meeting, and annual
Which
general.
provision has been violated?
You know, they have violated the clause A. Clause A B part 3. To receive, consider and pass the audited accounts of the preceding official year of the society
In the AGM.
in the AGM. It is the core subject matter of the AGM. It has not been submitted. It was not prepared. It was not listed in the agenda of the alleged AGM notice. Initial notice or dated 21st, which was followed.
That has lapsed.
Yes, Your Honor.
Now,
Thereafter-
now the council submission is that they're ready to follow the rules. And their audit of previous year is ready.
You know, when the auditor was appointed, every year the auditor has to be appointed as per the
No,
bylaws.
those plea may be taken during AGM if there is any.
No, you know, in every financial year, they have to hold a AGM. Unfortunately, in entire that 3 years, they have not hold any AGM. Not a single AGM has been called out.
No, those are not your plea. Your plea is only as regards violation of 15(3) to 15(1) B3.
B3. B3 and you are also to appoint a auditor, statutory auditor. To pass the proceedings of the last AGM. Last AGM was not held. You know, further, it has been alleged that the provision 16 of the society, 16 of the MOU has allowed the authority to the executive to extend the period for the period of 6 months. But whether any resolution has been adopted in this connection, whether any resolution of the members have adopted that the tenure is extended for another 6 months. Whether any such document has been filed with the repression. They have not exercised this power.
Now, what is the submission?
So they have already lost their all possible available rights. If they are claiming that they have a right under section 16 of the MOU, that a 6-month extension can be given to them.
No, on what ground you have challenged your grounds in the miscase?
No, our ground in the miscase was limited to
15 only,
ground to 15.
only 15.
You're right.
So,
Yes, Your Honor, 15.
so we'll not go beyond that in this.
No, your further 25 was also 25 was rescheduled when the matter was rescheduled to 25. It was also brought to the notice of the Honorable Court.
Is there anything in writing?
Yes, Your Honor, by filing the petition under Order 41.
The only issue, my lord, whether can they prevail beyond the pleadings of title suit? That's the issue.
Page 14.
We cannot say
My lord, may come to
beyond
page
the subject
14.
matter of the suit.
Page?
Page 14, page 78, my lord, sorry, page 78. 78. My lord, this was the petition that was filed on the very day of the passing of the impugned order, my lord. Chair, my lord, lordship may kindly come to page 79, paragraph 4. That the appellant has now come to know that the said AGM has been unilaterally rescheduled by the respondent committee to 25/9. My lord, why this 25/9 extended? Because 26 is the completion of the tenure of the society, my lord. That was tactfully, it was extended, my lord, without issuing any fresh notice. So that was the extension, my lord, with mandatory 21 days recordment. Repeatedly, my lord, they are doing and not in the entire their petition, my lord.
No,
Lordship,
those are not the ground. You have not taken those ground in your.
my lord, that is subsequent development after 21/9, my lord. And we have already filed amendment plan, my lord, regarding this, my lord, before the court below, my lord.
File application under Order 6 Rule 17 before the original body.
And lordship, we have categorically taken in our miscase, my lord, all the grounds with regard to, my lord, this violation of notice, my lord. And interesting, my lord, in that plaint, my lord, there are altogether several annexes. Only the copy of the plaint has been filed, my lord. Lordship may kindly come to grounds of appeal, my lord, in find. Page 37, my lord. paragraph 15, my lord, what illegalities, they are totally silent on their illegalities and criminalities. And we have filed a CR case also under different sections of BNS for misappropriation of fund, everything, my lord. I was a chartered accountant, my lord. I know the pros and cons of the financial things, my lord. Those other members do not know. So I was also a audit in my lord in 2014-15. Thereafter, after knowing all, they are saying that why I am only coming, why not others are coming. My lord, may kindly see non-circulation of audited accounts of the immediate preceding year. Clause 15 of the society rules and regulations mandates that the finalized audit accounts of the immediate preceding year must be placed before the members of the AGM. In the present case, the notice mentions audited financial year of 22-23 and 23-24. Every year they should do. Together, my lord, they are giving this, yes, and conspiracy omits the accounts of 24-25, violating mandatory statutory requirements, my lord. Well, can this amount of illegalities, criminalities be allowed, my lord, by running this present society, my lord? Non-circulation of annual reports, secretary's report. The society rules require the annual reports and secretary's reports for the relevant financial year be circulated to all members of the AGM. In the instance cases, reports of.
Mr. Dutta, you are issuing fresh notice.
Right.
Fresh notice for
21
convening.
days, as per rules.
21 days.
And also compliance of Rule 15.
Heard Mr. B. Datta, Learned Senior Counsel, assisted by Mr. S. Teka. Also heard Mr. N. Upadhyay, as well as Mr. D. Bakchi, appearing for, what is your name?
Vijay
B. Pandey, as well as Mr. D. Bakchi. Counsel for the respondents. This application.
Road Society has got void ab initio, my lord. That tenure is over, my lord.
That's not been extended by the committee.
Extended by the committee.
Application under Article 227 of the Constitution of India has been filed by the applicant, namely Shri Vishwanath Marwadi Databya Aushadhalaya, the President and Secretary of the said society, impugning the order dated 19/9/2025, passed by Learned Civil Judge Senior Division,
I
Dibrugarh.
am not impugned, my lord. 19-9 in our favor.
No.
The 24-9/2002.
Impugning the order dated 24/9/2025, passed by London Additional District Judge Dibrugarh in Miss J case number, in Miss Appeal number 2/2025. Whereby by the impugned order, the Court of London District, Additional District Judge Dibrugarh allowed the respondent to file an appeal against order dated 19/9/2025, passed by Court of London Civil Judge Senior Division Dibrugarh in Miss J case number 132/2025, and directed both the parties to maintain status quo in respect of the society and in respect of holding of the annual general meeting of the society, and remanded back the matter to the trial court to decide afresh, giving opportunity to both sides, and further directed to dispose of the matter within 30 days. The facts. Where is the impugned order?
Impugned order is page 84.
The facts relevant for the consideration of the instant revision petition are that the present respondent, namely Shri Sanjay Jain, Who? You are a member of the society?
Member of the.
I'm a member
Who
of
is a member of the,
and a chartered accountant by profession.
member of the petitioner number one society had instituted a title suit bearing number 104/2025, seeking a declaration that the annual general meeting within bracket AGM of the petitioners society scheduled to be held on 21/9/2025 is illegal, unconstitutional and contrary to law. Apart from the aforesaid declaration, the respondent also prayed for consequential relief of mandatory injunction restraining the present petitioners from giving effect to any resolution adopted in the said AGM. Along with the aforesaid title suit, the respondent herein also preferred an application under Order 39 Rule 1 and 2 CPC read with section 151 of the said code, which was registered as Ms. J case number 132/2025, whereby a temporary injunction was sought for restraining the petitioner society and his office bearer from holding the AGM or giving effect to any resolution passed therein, as well as from committing any act detrimental to the right of the appellant unless disposal of the main suit. The trial court, that is the Court of Learned Civil Justice Senior Division, Dibrugarh, had by order dated 19/9/2025 dismissed the Miss case wherein temporary injunction was sought for, mainly on the ground that the present respondent within bracket petitioner of that case failed to satisfy the court regarding the presence of balance of convenience in the favor of the petitioner of the Miss case, or that he would suffer irreparable loss if such injunction is not granted. Stop. Now, before this line, a line. Though the trial court found that prima facie case was there, however, uske baad ye line. Stop. The present respondent aggrieved by the aforesaid order dated 19/9/2025 has preferred an appeal before the Court of Learned Additional District Judge Dibrugarh, which was registered as Miss Appeal number 2/2025. In the said appeal, by the impugned judgment, the order dated 19/9/2025 passed by the trial court in Ms. J case number 132/2025 was set aside and the matter was remanded back to it for fresh decision on the matter after hearing both the sides. However, in the meanwhile, it directed both the parties to maintain status quo in respect of the AGM to be held by the petitioners' society. Being aggrieved by the aforesaid order of grant of status quo, the present petitioners have approached this court by filing the instant civil revision petition. Learned counsel for the petitioner has submitted that the main allegation, the main grievance of the respondent while filing the miss case number 132/2025 before the trial court was that the notice for convening the annual AGM was issued by the present petitioners without complying with the requirement of section rule 15(1)(b)(3). 15(1) within bracket Roman B within bracket 3 of the
Not
memo.
all the provision, my lord. All the provisions, yeah, section 15.
No, that is the submission of counsel for the
Yes, my lord.
15(1)(3), 15(1)(b)(3) of the memorandum of association and rules and regulation of Shri Vishwanath Marwadi Databhya Aushadhalaya. The said rule is quoted here in below. Start. Right, 15, general meeting, number 1, AGM. B, the items of agenda of such AGM shall be, number 3, to receive, consider and pass the audited account of preceding official years of the society. Stop. Learned senior counsel for the petitioner has further submitted that in the application filed by the petitioner before the trial court under order 39 rule 1 and 2, it was alleged. Where is the application?
Application is page 56, 48.
My lord, I take your lordship indulgence, my lord. 2 of the members of the society have already resigned in view of the completion of the tenure of the society, my lord. I have a copy of one of them.
Here, in the injunction application, they have not said anything, my lord. In the suit, at paragraph 4, my lord, what I submitted, that these grievances.
No
have been
injunction
continued.
application in para 4.
No, in the suit, page 24.
Page 50 also you see. Page 50. Para 4. Prima facie case. That
Yes.
finalized audited
Yes,
report.
Yes,
That is their main.
yes, that is the grievance.
grievance. क्या लिखा? the main grievance was, main grievance of the respondent, present respondent was that the AGM was sought to be convened without finalizing audited account for the financial year 2024-2025 and non-preparation / circulation of annual report and secretary's report. Stop. He, however, submits that in the meanwhile, the date mentioned in the notice date of AGM, which was mentioned in the original notice dated
9.
No, AGM will be held on 21.
original notice,
Original notice, I
that
have the
is,
copy with me.
that is
No, that they have not
21,
annexed.
21/9 to
Original notice.
2025 has lapsed. He
No,
further submits,
Original notice, they have not annexed, my lord.
No, there is the notice, my lord.
has lapsed. He further submits that the extended date of holding the meeting on 25th September 2025 has also lapsed. And therefore, he submits that the title suit filed by the present respondent before the trial court,
My lord,
Very-
amendment petition I have filed.
wherein, no, don't continue interrupting. क्या लिखा? Wherein, no, पूरा लाइन तो पढ़ो सुन. Has also lapsed, and therefore the suit filed by the present respondent, wherein the only relief was sought, only relief which was sought for was to declare the AGM scheduled to be held on 21/9/2025 as illegal, has become infructuous. He further submits that in the meanwhile, the petitioners, in the meanwhile, as the original dates, as date of holding the said meeting, that is on 21/9/2025, as well as the extended date for holding the said meeting, that is on 25/9/2025 have lapsed. The petitioners propose to issue a fresh notice, giving a fresh date for holding the AGM after complying with the statutory requirement as per the regulation 15 of the rules and regulation of Shri Vishwanath Marwadi Databya Ashuddhalaya. Learned senior counsel for the petitioners has also submitted that the First Appellate Court had erred in granting the order of status quo as no application under Order 39 Rule 1 and 2 was filed. Is it your submission? During
Along
the-
with that.
Along with the appeal.
And there was no prayer of permanent injunction and temporary injunction in the suit.
As well as in the suit, no prayer for grant of permanent injunction was made. Any other submission? On the other hand, learned counsel for the respondent has submitted that respondent is a member of the petitioner number 1 society and also a chartered accountant by profession, and therefore is conversant with the financial aspect of the affairs of the society. He further submits that the in the appellate court has correctly remanded back the matter to the trial court as there was no elaborate discussion correctly remanded the trial matter to the trial court and has directed the parties to maintain status quo in the meanwhile till the matter is decided. He further submits that in the meanwhile, the respondent has filed an application under Order 6, Rule 17 before the trial court for amendment of the plaint. What you want to amend?
To change, correct the date from 21 to 25.
Only that much. 25 has also lapsed.
My lord, but they have not, no, 25, they have, lordship may kindly the constitution
No,
clause
no.
15(3).
Answer my
21
query
days.
only.
Yes, 25 allowed.
Further for the no election agenda was.
Give me the copy. If I may.
Have the amendment application with you.
I have the copy. You kindly give. 21 days notice was not given, my lord. Violation of 15(3).
And for the election.
No, there was no prayer for permanent injunction.
Subsequent, the trial court will look the matter.
No, but apparently there is no prayer in
Yeah,
your plea. And that is one of the plea of the petitioner.
There is a two
That-
judgment, my lord, of our High Court. One is Justice Jayan Sharma, and that was followed in 2021 by Justice Surana.
That
So
when there
without
is no
permanent, no temporary injunction can be granted.
prayer for permanent injunction is there, you cannot see.
That is law.
Well, but the fact of the matter, is society is already nullified, my lord, because they have started to.
No, no, those things are not before this court. Under Order 6, Rule 17, what amendment you sought to?
Declare the rescheduling of the annual general
Okay,
meeting.
okay. Amendment, क्या लिखा? amendment seeking amendment of the plaint to incorporate the additional prayer as well as pleadings to the effect that the rescheduling of the date, rescheduling of the AGM of the Defendant Society from 21/9/2025 to 25/9/2025 without issuing fresh notice of 21 days as mandated under clause 3 of rules and regulation be declared illegal. Any other submission? I have considered the submissions made by learned counsel for both sides and have perused the records, including the impugned order. This court is of considered opinion that the the appellate court, without, while passing the impugned order, ought to have disposed of the appeal under order 43 rule 1R itself without remanding the matter back, as the time appears to be essence in this case, as the meeting, AGM meeting was scheduled to be held on 25/9/2025. That is one day after the date when the appeal was taken up for consideration. It also appears that though the first appellate court has set aside the order of the trial court mainly on the plea that, mainly on the ground that while dismissing the prayer for temporary injunction, it did not elaborately discuss the ingredients, namely balance of convenience as well as irreparable loss, which could have been caused to the present respondent, within bracket petitioners of this case. However, it appears that though the issuance of an order of status quo also operated as injunction in this matter, no specific reasons were assigned by the first appellate court as to why the order of status quo was granted in favor of the present respondent. Why the status quo was granted, which operated as an injunction in favor of the present respondent. Stop. it also appears that even in the application under Order 6, Rule 17 filed by the present respondent before the trial court seeking amendment of the plan, the main grievance of the present respondent is non-compliance of requirement as provided under Rule 15 within bracket 1 within bracket B within bracket Roman 3, which the petitioners are ready to comply now. Stop. It also appears that on perusal of the plaint, on perusal of the plaint, a copy of which is annexed along with this revision petition, it also appears that no prayer for issuance of permanent injunction was made by the present respondent, which itself weakens their case for grant of temporary injunction in this case. Stop. As the proposed date on which the AGM was scheduled to be held earlier, that is 21/9/2025 and 25/9/2025, to which the respondent had by which the respondent was aggrieved, and for which he approached the trial court by filing the title suit, have lapsed, and as the petitioners are ready to comply with the requirement of Rule 15 within bracket 1 in bracket B within bracket Roman 3 of the relevant rules and regulation, as well as for the other reasons stated herein above. This court hereby set aside the impugn order passed by the Court of London. Additional District Judge Dibrugarh in title appeal number, in Miss Appeal number 2/2025, subject to the condition that the petitioner may hold the AGM after complying with the provisions of rules and regulations of Shri Vishwanath Marwadi Databhya Ashodhalaya. With above observation, this CRPIO is disposed of at the motion stage.
Grateful, man.
My lord, liberty may be given to us to file any.
No, liberty is not required. You are at liberty always.
Grateful, man.
37.
Itu ঘোড়ায় দিও। Item 30. Yes, what is this? Yes. Mr. Roy,
Yes, sir.
what is this?
This is a lordship, I had filed a suit, lordship, in the court of the civil judge at number 3, senior division, number 3, Guwahati. And along with the injunction application. And that application was, ex parte injunction was not granted, only so called notice was issued.
Ex parte injunction was granted,
No,
refused.
not granted. So called notice was issued.
So against that, you have preferred this.
Yes.
What was the next date?
Next date was 6/6/25.
You have appeared.
We've appeared, Manoj.
You have
In
filed.
fact, the trial court is, trial suit is also fixed today.
And what has happened in this case?
This case, my lord, for now, nothing has happened because we've questioned maintainability of the suit, my lord. Otherwise, it is fixed for objection.
You can contest the matter before the trial
So we-
court instead
I
of
would have submitted that.
agitating this matter here.
No, lordship. Where the fact is this, lordship, there are many partnership firms.
No, no,
companies.
I have not gone into the matter. You have preferred a suit. And in that suit, you sought temporary injunction, relief of temporary injunction. And on the first day, court refused to grant you ex parte ad interim injunction and issued notice to the other side. Agreed with that, you appeared before this. But in the meanwhile, defendant have already appeared. The matter can be heard by the trial court and disposed of. If you are entitled to get temporary injunction, you will get there.
Lordship, what happened? There was the dispute between the plaintiff and the defendant arose, lordship. And thereafter, a conciliator was appointed, lordship, and the conciliator given a conciliation judgment, lordship, by which.
Where is the impugn order?
Impugned order.
145. 145.
It is along with the impugned order is annexed 3, page 145.
Yes, what is your submission?
Lordship, first of all, your lordship may please to come to the MEU which was executed between.
No,
the
no.
part-
Before that, what is your case? Why you preferred the title suit?
Title suit I preferred, lordship, that the present petitioner, they are also the partners or directors in the companies or the partnership firms. Then what happened? The respondent, your lordship, he started the misappropriation of the amount or siphoning of the fund, huge amount. Till the date of filing of the suit, 35 CR has been already siphoned off from the firms and the companies, lord. This is
Which
a
company? Protect.
Protect Group company, one of the biggest, largest builder of the any region, lordship. So, and this respondent, Manoj Kumar Jalan, he is the respondent, one of the respondents. He has started his own builder company in the name and style of Ambika Group, Lord. And he is siphoning the fund to his new firm, lordship. And in the all the partnership deeds, your lordship, there are provisions that all the partners will sign the checks or instruments of the bank, your lordship. So this was the condition, then a dispute arose and the dispute was settled by MAU law. At
Now,
MAU
what relief you are seeking in the title suit?
title suit, Lordship, the prayer of the title suit is that Lordship will please to come. Yes, page 26, Lordship. The Lordship will please to come to page prayer portion. This is a suit, Lordship. For at page 32, Your Honor, suit is for declaration, permanent injunction, mandatory injunction, and Your Lordship, in the prayer portion of the Your Lordship will please to come to page.
You are representing Protec.
Yes.
Okay. Yes, which page?
Prayer portion starts from page 56. Lord.
Not from page 56. No, you can tell me in the gist what relief you are seeking.
Present Lordship, the project petitioner, though petitioners are the partners, directors, he is not allowed to participate in the business and he is not allowed to even withdraw the money. They are also not allowed to see any documents of the firms or the company's, Lordship. Totally in contradiction to the Partnership Act or the Companies Act, Lordship. And even the respondent number 1 and 2 is the bank, Lordship. Bank is not recognizing the present petitioner as the partners or the directors, Lordship. Who singly the bank is recognizing the Manoj Kumar Jalan, Lordship, and he is issuing all the checks, Lordship. He is maintaining the income and expenditures account, Lordship, and with loan signature in a partnership deed. As per Partnership Act, Lordship, a single partner cannot be authorized to withdraw the money, Lordship, but the bank is doing that, Lordship. And though these disputes were arose between the parties, then Lordship, the and conciliation proceeding was held, and that Your Lordship, Your Lordship will please to come to pay IA page 146, Lordship. This fact was suppressed, Lordship, by the defendant's respondent. Page 146 of the IA. Page 146, Lordship.
No. Okay. What is there in page 146?
Lordship, here this is the MU, Lordship, which was executed between the petitioners and the
No,
respondent.
but when the matter is fixed, after issuance of notice, both the parties have appeared before the trial court.
Hmm.
You can agitate the matter before the trial court.
Lordship, they have filed a petition that the suit is not maintainable. The matter may be referred to the arbitrator, Lordship, whereas already the matter has been arbitrated. And this document was annexed with the plain, but the learned trial court they did not give any finding or any whisper, Lordship. Series of Supreme Court decision or our High Court decision, once the matter is negotiated through the conciliation, Lordship.
These submissions you can plead before the trial court in the miss case.
Lordship, they have filed an application under Section 8 of the Arbitration Act that is pending for disposal.
First of all, that will be decided, Lordship. They have filed in case of prior liability with the another partnership firm. They had filed an application under Section 9. They had obtained ex parte injunction. In that case also, Lordship, this this conciliation proceeding was suppressed, Lordship, in a fraudulent manner, Lordship.
Okay, okay, make your submission.
They have not filed the WS till now, Lordship, though and your Lordship, when they have not filed any written objection against the injunction application. So it will take long time, Lordship, to dispose of the such type of petitions, Lordship. Simply, Lordship, my limited prayer will be, Lordship, this, that the present petitioners who are the partners or the directors, they may be also allowed to sign the check, Lordship.
That will give you relief which you are seeking in the main suit. That is the relief which you are seeking in the main suit.
I have taken. Because as per the Partnership Act, Lordship, all the partners are entitled to deal with the bank, Lordship. First of all, this is see the fraudulent or conduct of the respondent defendants, your Lordship, when this ME was executed on 23rd of September 2014. The clause, Lordship, the clause 4 provides that office and other infrastructure will go to single family. That is the petitioner.
Where is the MOU?
MU page 146
Okay, 146.
of the IF.
This MOU was
Executed on 23rd of September 24. Lordship.
between whom?
Between Lordship, the single family and the Manoj Jalan family, Lordship. All are signatories. I am allowed to read.
Yes, please. Read.
Today, 23rd September 24, in a meeting attended by Mr. Manoj Jalan, son of Mahavir Prasad Jalan, in presence of Aditya Parasramika, he is the conciliator, as a mediator, with representatives of Indumati Singhal and the family following, has been decided that Dharapur project under Aero City Private Limited will be given to the single family, that is petitioner, except for phase 1, which is already sold out and will be completed by March 25. Manoj Jalan will have 50% share of profit in phase 1 project of the Dharapur. Number 2, Ujan Bazaar project about 2 bighas protects Sunanda Lokesh Enterprise project, which is a development agreement of 2033 7 lesser, and land available for project is the 21 bighas 3 lesser. Hence, the remaining land has not been considered in valuation, and in future, if permission is obtained on more than 21 bighas 3 lesser, the extra land FAR will have a claim of 50% of the single family and the building share of the area. Clause 3. Protect Pride, a partnership firm, will be 100% to Manoj Jalan, that is the respondent, Lordship. Clause 4. Properties of the Protect Center and the rental properties of the Changsari where house the 3 numbers are already constructed, and the construction will be completed for finally being offered for rental purpose, will go to the single family, that is the petitioner. Then clause 5, warehouse of Bongra and Protect down rented property will be entirely go to the Manoj Jalan family, that is a respondent. Clause 6, office and other infrastructure will go to the single family, that is the petitioner. Project at Tarunnagar will be completed jointly. There are, clause 8, there are properties or land which are disputed, litigated for some or other reasons. All such land will continue in the joint account reference connection descendant. Clause 9, other land parcels which are after purchase or not delivered or in a process of the acquisition will continue to be held jointly. Clause 10, the protect grant 18 bighas protect has 50% share in the total land, out of the which 50% is for Manoj Jalan, that is respondent, Manoj Jalan family share. That mere 25% of total land, this will be swapped to the land at the Gorchok phase 1. At Gorchok, 12 bighas land share in 50-50 for single and Manoj Jalan family. After swapping the land of Grand Land Gorchok 1 with single family, whatever remains Gorchok 1, the remaining land will be under the holding of the single family. As such, and when project is taken up, proportionate share of the area will be demarcated to single family. Cost of the construction for this area has been fixed at rupees so and Mr. Manoj Jalan will get rupees 200 square feet in it for doing the construction of the proportionate area of the single family in the total land. Clause 9. For Dharapur on land 1 bigha 7 lacha, if the owner land is acquired by the government, the compensation from it will be shared amongst both parties equally, 50-50%. If the government does not acquire the land, then from the land area of 1 bigha 7 lacha, half share 50% of the equal area to 53.5 lacha will be deducted from the single family share in the Gorchok. All the single family and the lordship, the Manoj Jalan family signed this MU lordship, which was a conciliation award. Now your lordship will please to come to the how they have.
Where is the signature of Manoj Jalan?
Lordship, on the right side, first signature. First signature. Then at the middle, your lordship, Vivek Anand Singhal, he is also one of the partners or directors. And the present petitioner Lokesh Singhal signature is at the bottom. And supplying in lordship, this was never challenged. And when the respondent lordship filed an application under section 9 of the Arbitration Act for interim measure, this fact was suppressed, lordship. Your lordship will please to come to the petition filed by the respondent under section 9. Page lordship 345 or IA.
IA.
345 lordship
Of
the objection filed by my learned friend. Here.
In the IA itself.
IA.
We are hearing main CRP or IA. CRP
Appeal has
can be,
been already admitted, lordship. Appeal has been already admitted. Now your lordship is hearing the IA. They both can be disposed of, lordship.
whether CRP can be disposed of.
No, not CRP, appeal.
Yes,
Under order
sorry.
43, rule 1.
Appeal can be disposed of.
Yes,
today.
lordship, because keeping the.
Mr.
pending
Dekha, what is your sir?
I would say, my lord, the appeal is only for the ad interim period.
Yes, therefore,
In fact, I would submit, my lord, it has become infructuous in a way.
so we can
Because-
dispose of appeal also.
Appeal also perhaps.
It can be disposed of. I am not.
Okay. Okay, then you make submission in that aspect. We are disposing of both the appeal and the IA.
Okay. Lordship, will please to come to page 345.
IA.
345 of the affidavit in opposition filed by the respondent lord. Annexure D. This is the application filed under section 9, lordship. by the respondent. Lordship may be pleased to come to page 350. Continuation page and internal page is 6.
What is this?
This is the application filed by the respondent under section 9. After the execution of the conciliation order, Lordship, dated 23rd, 9/24. Page 350, your Lordship, was filed in the middle, an application under section 9 of the Arbitration and Conciliation Act.
Yes.
Here, your Lordship will not file any whisper regarding the MU Lordship executed between the parties, that is the MU dated 23rd of September 24. This vital document was suppressed as because Lordship, the respondents were fully aware that if that MU dated 23rd September 24 is annexed or filed along with the petition under section 5(9) of the Arbitration Act, the respondent will not get any ex parte injunction order against the present petitioner. So that's why this vital document was suppressed in a fraudulent manner. Now, your Lordship may be pleased to come to the prayer portion of the petition under section 9 of the Arbitration Act, Lordship, which is unheard, unparalleled. Partners were restrained, Lordship, from operating the bank account and participate in the day-to-day affairs of the partnership firm.
No, this application was filed in a separate proceeding, not
In case of one of the partnership firm, Pride Realty.
a separate proceeding, arbitration case,
Yes.
not in this title suit in which the interim.
No, that I already have submitted, Lordship, in case of the Pride Realty, Lordship, Pride Realty case, Lordship, the respondent had filed an application under section 9. Because, Lordship, in the MU, the Pride Realty is also involved, Lordship. So that's why I would like to place before your Lordship the conduct of the defendant's Lordship respondent regarding where there is any whisper. And thereafter, the learned trial court civil judge number 1 senior division, Metro Lordship, passed an ex parte injunction order against the petitioner, prohibiting him from Lordship signing any check or not to disturb the respondent number 3, Manoj Jalan, Lordship, to interfere in the business or by for issuing of the checks and other monetary instruments, Lordship. So a single partner, Lordship, though your Lordship, the single family, that is the present petitioner, they are the stakeholders of 75% of the share. And Manoj Jalan and his family is a minor stakeholder, Lordship, having only 25% of the majority shareholders, Lordship, of the companies or the partnership or the LLPs have been deprived of from taking part in the day-to-day affairs of the company, Lordship, or the partnership firms or LLP, Lordship. This is unheard, unparalleled, your Lordship, because the Partnership Act itself provides that all the partners will do the business in consultation with each other, and all the partners will be entitled to sign the checks or to deal with the customers, Lordship. So these are the mandatory clauses in the Partnership Act, and all the partnership authorizes all the partners to take part in the day-to-day affairs of the business of the firm or company, Lordship, and also to sign the check, Lordship. But here in the Honorable Court granted in ex parte injunction order that your Lordship will
But that
find.
is not under challenge in this case.
No, it is relevant, Lordship. It is, Lordship, one of the defendants themselves have stated in their several petitions that Protect Group is all entities are a common group. That is not disputed, Lordship. That is not disputed. Ex parte order. Ex parte order. Lordship, may you please to come to Lordship memo, Lordship, may you please to take up the file. Huh?
Yes.
Lordship, I am pleased to take up the objection filed by my learned friend in the ILFC before this honorable court and come to page 373. 373. Annexure E.
This objection is filed again in that arbitration case.
No, this is not, this is, this ex parte injunction was passed when the application under section 9 of the Arbitration Act was filed. For interim measures, passing the interim measure. Here, Lordship will find Lordship may come to page 11 portion, page 386. 386.
86.
Yes.
Yes.
386 Lordship, para 15, last para. In accordance with the principles of justice and equity, this court finds it imperative to issue an addendum injunction order under the following terms. An order of addendum injunction to forthwith defreeze the current account number so and so of the petitioner number 1 firm held with OP number 2 Indus Bank, Ganeshguri branch, and debit payment request made concerning transactions of the said bank account prior to the date of freezing. An injunction to restrain the OP number, present petitioner's appellant Lordship. An injunction to restrain the OP number 1 from taking any action as steps for closing, freezing of the transaction in the bank accounts of the petitioner number 1 firm, post defreezing of the said current account of the petitioner number 1, and from taking any steps from freezing the accounts of any sister company, subsidiary, or the parents companies firms of the petitioner. Para 16, the temporary injunction order will remain in effect until the OPs appears before this court. Meanwhile, the petitioner is permitted to initiate arbitration proceeding as per the agreed terms and conditions. This is vital, your Lordship. Please to know. The respondents were directed to initiate the proceeding for the appointment of the arbitrator, Lordship. And thereafter, the respondents are sitting idle. Simply they had issued a notice to the present petitioner, Lordship, for appointing the arbitrator, Lordship. Thereafter, nothing was done. Till date, no application has been filed by the respondent under section 9 of the Arbitration Act, approaching the Honorable Chief Justice of this Honorable Court for the appointment of the arbitrator, Lordship. And Lordship, here, Roman 70, so-called notice to be issued to the OP, taking them to provide valid reasons with the injunction should not be permanently in force against them. For 18, para 18, for transparency of the compliance, the petitioner must promptly send copies of these are the steps process, your Lordship. And next date was fixed on 9/1/25. We appear, the petitioner's appellant appear before the learned trial court of Lordship and file the objection, petition for vacating the ex parte injunction order, Lordship. And that is still pending, Lordship. That was filed long back.
But that relates to a different case.
Different case, but same entities, Lordship. I have already submitted.
Maybe. Have you impugned this order which you are referring now?
No, in that, Lordship, in the present suit.
No, if we take very simply, in the title suit filed by you,
yes,
in respect
yes,
of
there
which
also, Lordship.
present FIO has been
I
filed.
had annexed this MU dated 24/9/24 was annexed in the present suit, Lordship. And there was lengthy argument before the learned civil judge, senior division number 3, but the impugned order your lordship will not find. Whatever till now I have submitted before lordship, I have submitted that
No.
the
Just a minute, let me put a query. You want to show that while making application under
nine.
Section 9 of the Arbitration Act, the present respondent suppressed the MOU before the said court. This point you want to press.
Yes. Because section 9 petition was not maintained. In view of the fact the matter was already arbitrated through the
Okay,
APU.
suppose it is accepted, your submission is accepted, then how it will impact this case?
This will dispose, this will cause irreparable injury to the present petitioner as because lordship in the present suit your lordship Pride Realty against which Pride Realty which has filed application under section 9 of the Arbitration Act is not a party in the present suit.
Yes.
Is
but
not a party.
Yes, it is not a party.
It is not a party in the present suit lordship. But all the properties lordship which are involved in the present suit are covered by the MU dated 23rd 9.
So what you want to impress? What you want to say?
Impress lordship that until and unless lordship. Simply my humble prayer will be lordship, that lordship, that I may be allowed to sign the checks along with the other partners lordship. So that will protect both the parties lordship.
No.
And which is the
You are against, you have approached this court by filing this FIO against an order of ad interim ex parte, refusal to grant ad interim ex parte injunction. But the trial court has not dismissed your case. It had issued notice, and in pursuant to that notice, the opposite parties have appeared. Now your case that ad interim ex parte injunction was not granted to you, it has lost its force. You can argue your case, and the court can decide after hearing both the sides whether you are entitled to get temporary injunction or not. There is nothing which bars you from pleading your case before the trial court now.
my
Submission.
submission apprehension in this lordship. While discussing the 3 golden principles of the injunction jurisprudence lordship, prima facie case, competing balance of proof, irreparable loss and injury, the learned trial court has not discussed anything regarding the MU lordship, which was executed between the parties lordship, which has caused serious prejudice to me lordship. And apart from that, your lordship, in the plaint, your lordship, in the plaint, present plaint lordship, I have annexed the copy of the plaint lordship, and there plaint के माने annex. Lordship, may be pleased to take up the plaint. Page 26, annexure 1, along with annex with memo. के बारे में कहा
Page number?
Page. Lordship, the plaint starts from page 26, annexure 1.
26 of the
lordship memo. How?
Yes.
Page 26, lordship. This is the copy of the plaint. Now your lordship may come, please to come to page 54. Continuation page 54. Internal page 29.
Yes.
Lordship got it?
Yes.
Page, para 41
Yes.
of the plaint. MU terms of the settlement. After multiple attempts and the persuasion by the plaintiff number 2 to Sri Manoj Kumar Jalan, defendant number 3 to come to the terms of the settlement and distribute assets of the Protect Group to part aways with Sri Manoj Kumar Jalan. One Sri Aditya Ramka acted as a mediator to settle the dispute between the parties. And through the said mediator, Sri Lopesh Anand Singhal, plaintiff number 2, and Sri Manoj Jalan, defendant number 3, and Sri Vivek Anand Singhal, defendant number 4, came to the terms for a resolution of the dispute and executed a memorandum understanding dated 23/9/24 terms of the settlement. Lordship, the MU was a conciliation and arbitration award to settle the dispute and distribute assets of the Protect Group. The possession and custody of the original copy of the said MU with Sri Vivek Anand Singhal, he is one of the defendant number 4, and he may be directed to produce the same if and when required, Lordship. So, Lordship, the specific plea has been taken in the plaint, Lordship, that after execution of the MU, Lordship, which was a conciliation proceeding, Lordship, the fact was suppressed, Lordship. And apart, even then, your Lordship, the assets, both movable, immobile properties have been partitioned between the two parties. In spite of that, Lordship, the respondents are not allowing the plaintiff petitioner, Lordship, to run their business, which were allotted to them as per the MU, Lordship. Rather, Lordship, the bank is recognizing only Sri Manoj Kumar Jalan as the authorized signatory. No Lordship, the filing of the KYC is mandatory, Lordship. One respondent is not filing any KYC, Lordship. A series of letters have been given by the bank, Lordship, to Manoj Kumar Jalan for submitting the latest KYC as per the RBI guidelines till date, which has not been submitted by the respondents, Lordship. So, Lordship, the law is this RBI guidelines that if KYC is not submitted, Lordship, once it is demanded, the account will be kept under suspension. All the accounts will be kept until and unless the KYC is updated, Lordship. So, Lordship, I'll confine my argument to this MU, Lordship. It is such a vital document, Lordship, because once a MU or matter is consolidated, Lordship, this petition under section 8 or 9 of the arbitration cannot be entertained, Lordship. Cannot be entertained. There are series of apex court decision, our high court decision, Lordship, cannot be entertained. And this vital, Lordship, I have moved personally the injunction matter, Lordship, before the learned trial court. And especially I have placed this MU para, Lordship, and document also which was executed on 23rd of September 24. But the Lordship in the impugned order, your Lordship will not find any whisper. No finding. It is perverse find. It is entire impugned judgment is perverse, Lordship, that your Lordship will. Lordship, actually the bank in collusion with the respondent, Lordship, they are allowing the transaction crores of rupees to be drawn from the accounts of the companies and firms, Lordship, which are causing grave legal injury to the petitioner. And once the respondent has started his own builder company, that is Ambika Group, Lordship, and he is siphoning of the money. And if it is not a stop, Lordship, the petitioner's company which has come to their share as per the MU become bankrupt, Lordship, causing serious legal injury. And there is, Lordship, there is no order from the any court, Lordship, that only the defendant number 3, that is Manoj Kumar Jalan, will operate all the bank accounts of the firm as well as the companies and LLPs. In spite of that, Lordship, the bank is respondent number 1 and 2 are the bank and official. They are allowing the respondent number 3 to operate all the bank's accounts, Lordship. It is unimaginable, Lordship, unheard that in a partnership only a single partner will transact the money, Lord. Now, your Lordship, may I please to come to. We have filed an additional affidavit. Your Lordship, may please to take up the additional affidavit. I'd like to place the bank's letter directing the respondent to proceed with the KIC.
Page number.
Page number 399 of the additional affidavit. Continue.
It is filed in the IA.
It is filed in the IA. Additional affidavit. It is was filed on 16th, no? 16 September 20.
Yes, what is this?
This is the letter of the Indus Bank Lordship dated on the top left side, your Lordship will find dated 31st/12/24 to protect housing, Lordship. And submission of subject is Lordship, submission of the customer up to date KYC document for this and that. Customer number so and so. Greetings. Thank you for you are in delighted to have you our valued customer and hereby seek your cooperation in your KYC document reviewed and up to date with the Indus Bank. As you are aware that the Reserve Bank of India has made mandatory to bank to review and update the KYC details of the firm company or for constitution of a periodic consultation on a periodic basis. These procedural reviews form an integral part of the compliance policy and we solicit your support in ensuring adherence to the same. We request you to undertake the following actions pertaining to your KYC review latest by 7th January 25. Then Lordship, another letter was given by the bank. Lordship page Annexure B, page 403 law. This is the letter dated Lordship 9/1/25. In the light of the dispute complaint issued by Lokesh Singhal, that is one of the appellants, with the bank and the RBI, with regard to the Protect Group account, the bank has initiated process of obtaining latest KYC document and updating the same in the bank record. The addresses and the concerns raised in your letter responsible as under. Then Lordship may come to clause the most relevant portion, para 6 of this letter. We refer to RBI circular direction, know your customer direction 2016 by the master direction division number so and so is updated as on 6th November 2024. The the circular in part 5 on going due diligence, updation, periodic updation of the KYC, customers, individual clauses 2, states a change in KYC information. In case of change in the KYC information, RE, regulated entry, shall undertake the KYC process equivalent to that application for onboarding a new LE, legal entity, customer, and also the general declaration. These are the guidelines, Lord. And next, Lord, please to come to page 405. Third letter by the bank to the respondent, Lord.
Now, what you want to submit that in spite of request from bank, it is,
If the KI law is this, Lordship, as per the RBI circular, and if the KIC is not updated, the bank will keep all the accounts in abeyance. There cannot be any transaction. And Lordship, may you please, that is it. Even our High Court Division Bench judgment is there, Lordship, that if KIC is not updated, the account should be kept under suspension. That citation is, Lordship, our High Court.
where is the RBI guideline to that?
Yes, yes, RBI. Yes.
So what is your submission? As the Protect has failed to update the KYC, the
Lordship,
account should be
kept
freeze.
under but we don't want suspension of the account law. Because, Lordship, the large number of persons have booked the flat. They will be the actual sufferer, Lordship. They will be the actual sufferer, Lordship.
Then why are you showing these bank
Lordship,
letter?
because I am the partner, Lordship, and we are the partners of the different firms, companies, directors in the different companies, Lordship. And if, Lordship, I am not allowed to participate in the affairs of the business as well as to sign over the check, Lordship. Already I have submitted the Manoj Kumar Jalan, the respondent has siphoned more than 35 crores of rupees from the single Protect group to his own group, that is the Ambika group, Lordship. So that is causing serious legal injury, Lordship. And your Lordship, our High Court judge.
What was the prayer before the trial court in this case? What interim, what?
Interim prayer, that all partners should be allowed to sign and participate. That was the main prayer. Here, your Lordship, you see the collusion between the bank and the respondent.
No,
The bank has written letter to the respondent, Lordship, for updating the KYC, but they are not for responding.
you sought for temporary mandatory injunction.
Temporary mandatory injunction, Lordship. Just kindly allow me to place a judgment.
Yes.
I'll place that on. High Court का कौन सा है? High Court का you given to court. Lordship, I have given the citation. Bunch. Your Lordship, may you please to come to page 2. No, sorry. Page 46. Page 46, Lord. I have done the pagination. This is our own High Court Division judge.
Page 46.
Page Lordship 46. Para 5 is, this is a division bench judgment, then the then Honorable Chief Justice and Justice A.K. Goswami, para 5, it is the relevant. Lordship, may please to come to page 48, para 5.
Yes.
In the right, In the light of the rival contention and a perusal of the appeal papers, more particularly the affidavit in opposition filed by the respondent, the position would be clear that the appellant in any event have offered himself as a guarantor in respect of the loan amount that has been advanced by the respondent back to the borrower, whose names are indicated in Annexure A3 to the affidavit. Then your lordship may escape and come to 1, 2, 3, 4, 5, 6, 7, 8, 9. Para 9 from the bottom. Para 9 from the bottom. Though that with the position, has your lordship got it?
Yes.
Yes. That though with the position, since the respondent bank have also indicated in the affidavit filed this an appeal that the appellant has not complied with the KYC norm. Certainly, the appellant is required to comply with the same, as otherwise the regulation of the RBI would not extend satisfied. It is further clarified that the appellant shall contract the respondent bank and furnish the details so as to comply with the KYC norms on compliance of the same if the 50% amount as permitted by the executing court is not being deducted, the respondent bank shall deduct the same from the account of the appellant, and thereafter the appellant be permitted to operate the bank account without any other impediment. To enable the said process to be complied, the appellant shall comply with the KYC norms within the time frame fixed by the respondent bank, and in compliance of the same, the process of appropriation of the 50% of the defaulted amount be made, and the account of the appellant be operationalized, and the appellant be permitted thereafter to operate the account in accordance with law. In the present case, lordship, when the KYC was not submitted by the customer, lordship, the account was kept under suspense. And thereafter, when the judgment was passed by division bench of this honorable court, they had acted as per the direction given by this honorable court, lordship, and before that, the account was kept under suspension. Now, therefore, lordship, your lordship may be pleased to come to page.
No, these submissions you are making to impress upon the fact that if KYC is not given, your account may be freezed or suspended. You can show the regulation, that is enough. If there is any RBI regulation to that effect.
I have already given, no? Already I have submitted. I have not placed, but I have given. Lordship. Lordship, no, ये क्या है यार इसमें? Lordship, I have given RBI guidelines, lordship. Lordship, got it?
Yes, yes.
Lordship may come to page relevant portion, page 44. Page lordship, page 44 at the bottom, lordship will come. It is a part of the rule 39.
Yes.
Lordship 39, in case of existing customer, RE shall obtain the permanent account number or equivalent e-document thereof form 60 by such date as may be notified by the central government, following which RE shall temporarily cease operation in the account.
What is the meaning of RE?
Regulated entity,
Okay.
which is bank, relating to KS. I shall temporarily cease operation in the amount till the time the permanent account number or equivalent e-document thereof or form number 60 is submitted by the customer. provided that before temporary seizing operation for an account, the RE shall give the customer an all accessible notice and a reasonable opportunity to be heard further. RE shall include in its internal policy appropriate relaxation for continued operation of the account for customers who are unable to provide the permanent account number or equivalent account thereof or form number 60. Owing to injury, illness, infirmity on account of the old age or otherwise, and such like causes, such account shall however be subjected to enhanced monitoring. Provided further that if a customer having an existing account-based relationship with a RE gives in writing to the RE that he does not want to submit this permanent account number or equivalent document thereof or form number 16, RE shall close the account and all obligations due in relation to the account shall be approximately settled after establishing the identity of the customer by obtaining the identification document as applicable to the customer. Explanation: for the purpose of the paragraph, temporary ceasing of the operation in relation to account shall mean the temporary suspension of all transaction or activities in relation to that account by the RE till such time the customer complies with the provisions of this paragraph. In case of assets account such as loan account, for the purpose of ceasing the operation in the account, only credit shall be allowed. And in spite of that, Lordship, 3 letters, and recently, Lordship, after filing the present appeal and the IO, Lordship, the bank has again issued letters to the defendants for updating the KIC letter. This is not on record, but it was served to me only 2 days back, Lordship.
Okay, now what do you want to submit? The defendant have failed to submit KYC, so the account should be suspended.
No. What is suspension of?
Then what is your service?
No party will suffer any injury. Simply I want that the appellants may be allowed to sign the checks and allowed to participate in the business. Because, Lordship, I have quoted the provisions of the Partnership Act. No partner in a partnership firm, Lordship, no partner can be prohibited from participating in the affairs of the Partnership Act. And all partners are entitled to sign the checks. Lordship, please to take up the Partnership Act. Even though in our petition also I have put it. Lordship, may be pleased to take up section 9, sir.
No, okay, we admit that. Say all partners are
Having equal, only their loss and profit may be different. But other things, operation of bank account, joint, Lordship,
So
singly.
it depends upon what kind of account you are holding. If it is a joint account, the requirement of signatures of joint account holder would be required.
All in our partnership, deed, Lordship, I have annexed, it is provided that all the partners of the firm will operate the bank account joint.
All or any?
No, all. Or all partners may authorize 1 or 2 partners. But previous first line is that, 2, 3 lines in this, Lordship, all partners will operate the, open the bank account jointly and operate jointly.
Jointly.
Yes,
Okay.
Lordship. Just your Lordship will please to come to page 83
Of
of the IA. Page 83.
you have to close within 5 minutes. Otherwise, he has to reply also.
case, your lordship,
How much time?
it would take some time also. If your lordship, then it may be taken on Tuesday. And ready to. It may remain,
What else you want to submit?
there are many other points. Rodul Excel, for signature of the by defendants, your honor. For illegally withdrawing the money, lordship. Nothing has been considered by the landed trial court while rejecting my petition.
Yes, Mr.
It may be taken
Once,
soon.
once my friend concludes, I can begin. I shouldn't take long, Lord. But,
How much time will it take?
I'll try to finish by half an hour.
Half an hour will be required.
40 minutes.
You also require how much more? You have already consumed more than 1 hour.
Lordship, at least I'll take an hour.
Yeah,
Bank
that's
is
also
there.
for the bank.
So this
Then
may be
it
taken on
is
Tuesday.
unlikely to complete today. We cannot even reserve it for declaration.
Lordship, it may be kept part-hard, it may be hard to it. Diwali. अरे तुम सब जगह study में.
Suggest a date.
Or it may be fixed on 23rd.
When is the next date
20.
fixed before the trial court?
Today was the date fixed, Manoj. We are not aware of what. date
Today you
has-
have not appeared.
We've appeared.
Somebody has appeared.
We've appeared. Yes. We've appeared. They.
We have appeared, we have filed our objection against the petition filed by the respondent under section 8 of the.
They filed their, they were supposed to file.
I filed.
Section 8.
Yes, now they have started. And the presiding officer is, has not joined in. Earlier presiding officer has been transferred to. as a
Okay, you
citizen.
choose a date.
There is no judge now.
Suggest a date.
लो अरे भाई तो क्या है तुम रहो ना मैं दो जना लगे 24th it can be both of us agree
24th.
Twenty-third. 23rd. Hearing takes away.
23rd. Third, Mr. S.P. Roy. Come on, item number. Third, Mr. S.P. Roy.
30.
Learned counsel for the appellant / applicant. Common order হবো দুটা common order হই copy এটা miss কেসত রাখিম. Also had Mr. B.D. Deka, learned counsel for respondent number
3 and 4.
3 and 4. Here it is shown as 3, 4, 5, 5, 6, 7, 8.
I stand corrected.
3, 5, 6, 7, 8. Also had Mr. M. Das, A.K. Gogoi, appearing for respondent number 1 and 2. Due to paucity of time, the hearing could not be concluded today. We'll finally dispose of the matter.
Yes, yes.
Let this matter be listed again on 24th. 30. 10/2025 as part heard matter.
Objection filed by my learned.
I'll serve it.
You serve it. I'm not reflecting it in the order.
Obliged. तुम्हारे अनुसार तुम्हारे
This is a delay petition, Lordship. As per the office note, Lordship, the service on 2 and 3 is not yet complete. It has not come. But it can be deemed served, Lordship.
How?
Because it was sent more than 1 month back.
No, let us call for the track consignment report. It has been sent through.
My lord, I am for the respondent number 1, my lord, in this case, Arun Chandra Pal. My lord, as such, I do not have any objection, but delay is condoned. Only small request is this, my lord, I am 76 years old now. If the appeal can be, my lord, condoned and listed for hearing, my lord.
Who are 2 and 3?
2 and 3 is, my lord,
Owner and
driver, my lord, in this case.
You have receipt so that we can draw presumption. We'll fix a short date. Heard Miss R.D. Majumdar, learned counsel for the applicant / appellant. Also heard Mr.
AB Day, my lord.
A.B. Day, learned counsel for respondent number 1. It appears from office note dated 9/10/2025 that the notices issued to respondent number 2 and 3 have not yet been returned. Stop. The registry is directed to place the track consignment report of the notice issued to respondent number 2 and 3 by registered post on the next date fixed, along with the case record. Let this matter be listed
On 23rd, my lord.
on 23rd of, instead of 23rd, let it be 24th.
My lord, please.
24th,
My lord.
because file movements take also time. 24th October.
Your Lordship. Also, there are 3 RAs, Your Lordship, for substitution, condonation of delay, and setting aside abatement, Your Lordship. Lordship, may kindly take up IA 1, 2, 2, 3, Your Lordship.
1, 2, 2, 3, 4.
It is for condoning the delay in
1, 2,
filing the
1, 2,
substitution petition.
You're opposing,
No, your lordship, I'm not.
conceding. Heard Mr.
H. Buragohain.
H. Buragohain, learned counsel for the applicant. Also heard Mr.
As Gautam, your lordship.
S. Gautam, learned counsel for respondent number for all the respondents. This application under Section 5 of the Limitation Act 1963 has been filed by the applicant for setting aside, for condoning the delay of 725 days in preferring the application for setting aside abatement as well as substitution on death of the appellant. Who was the original appellant?
Your Lordship, Nripen Mohanta.
When he died?
Your Lordship, on 19/8/2022.
Death of the appellant. Stop. Learned counsel for the applicant has submitted that the cause for approaching this court belatedly beyond the prescribed period of limitation has been stated by the applicants in paragraph number
Your Lordship, 5, 6.
5 and 6 of the application for condoning the delay. Stop. Learned counsel for the respondents has submitted that considering the grounds shown by the applicant which caused the delay in approaching this court in preferring the application for setting aside abatement as well as substitution. He does not have any objection if the delay of 726 days is 725 days is condoned. So considering the submissions made by learned counsel for the respondent, as well as considering the ground shown in the paragraph number 5 and 6 of the delay condonation petition to be sufficient ground which prevented the applicants from approaching this court within the prescribed period of limitation for setting aside abatement, the aforesaid delay of 725 days is hereby condoned, and this interlocutory application is accordingly disposed of. Then abatement,
IA 1222.
council नाम एके लिखिबो. This application under Order 22, Rule 9 of the Code of Civil Procedure 1908 has been filed by the applicants for setting aside the abatement of the connected RFA number 131/2019 on death of the appellant Nipin Mahanta, who expired on
19/8/2022.
19/8/2022. Stop. The learned counsel for the respondent has not opposed the prayer for setting aside of the abatement. Stop. Considering the submissions of learned counsel for both sides, as well as ground shown in the application for setting aside abatement, the prayer is allowed. The abatement of RFA number 131/2019 on the death of Nipen Mahanta is hereby set aside, and this interlocutory application is accordingly disposed of.
Okay, next is IAC 1221.
This application under Order 22, Rule 4. Now, Order 22, Rule 4 of the Code of Civil Procedure has been filed for substituting the legal heirs of deceased appellant, namely late Nipin Mahanta. It is pertinent to mention herein that on death of the aforesaid appellant, the connected appeal number 131/2019 got abated. However, by order dated 16/10/2025, passed in I number 1222/2025, the said abatement has been set aside. By this substitution petition, names of the legal heirs of deceased appellant Nipin Mahanta, deceased appellant, namely Srimati Kalyani Mahanta, within bracket his wife, and Miss Trishita Mahanta, his daughter, are sought to be substituted. Learned counsel for the respondent does not have any objection to the said prayer for substitution. Hence, the prayer is allowed. Let the name of Srimati Kalyani Mahanta and Miss Trishita Mahanta be substituted in place of original appellant as appellant number 1 within bracket 1 and 1 within bracket 2. Stop. The applicant shall file an corrected cause title in the aforesaid memo of appeal. In the memo of appeal of the aforesaid appeal, incorporating the names of substituted appellant in pursuant to this order. This interlocutory application is accordingly disposed of. corporate, last line to production. Within substituted appellants in person to order that it's so and so within 2 weeks from the date of this order. List this interlocutory application is accordingly disposed of. Registry to list the connected RFA accordingly.
In terms with the but in terms with the order dated 29/8, I was supposed to take steps upon respondent number 12. And regarding the respondent number 3, in the meanwhile expired. So we are supposed to file appropriate application, and respondent number 12, there's a change of address. We have taken these steps. On 13th, we have taken steps upon 12, although it is not tagged along, it is not shown in the office note. And on 14th, we have filed the appropriate applications. And we have served one of the respondent the copies of the application. I don't know. I'm from respondent for whom he is representing.
But it is not
Yes,
placed.
it is not tagged along with the record.
Okay. Heard Mr. N.P.V. Singha, learned counsel for the what for IA is pending?
This IA is for delay. Delay of, in the meantime, Lord, we came to know the respondent number 3 has expired. The appellant in the respondent number 3
This IA is condonation of
for
delay.
delay, and it is for 7 days of delay. And now we are
Delay for filing what?
the appeal, the connected appeal.
Appeal has not yet been
It is
registered.
not yet been registered.
Then how RSA has been numbered as 6948?
This is filing number.
Okay.
Filing.
Likho. Heard Mr. N.P.B. Singha, learned counsel for the applicant. Also heard Mr.
D. Burwa for respondent number 4.
D. Burwa appearing for respondent number 4. Learned counsel for the applicant has submitted that the applicant has taken steps for issuance of notice upon respondent number 12 in pursuant to the directions of this court by order dated 29/8/2025. Stop. However, the office note does not reflect anything about that. Stop. The registry to verify and put up an appropriate office note to that effect in the next day. For the applicant has also submitted that in the meanwhile, it is informed to the applicant that respondent number 3 has already expired. And accordingly, the applicant has filed a substitution petition.
Substitution as well as IA for substitution for delay for abatement. 3 applicants were filed.
Accordingly filed appropriate
Yep.
applications for setting aside abatement, condonation of delay and substitution. However, said interlocutory applications are also not tagged with the record. Registry to list the aforesaid application along with this interlocutory application on the next date. List this matter after 3 weeks.
After 3 weeks, 2 weeks maybe.
After 2 weeks on a date to be fixed by registry.
All right.
Item number 23, 24. Looking for accommodation. Can you be on first week of November?
Yes. Even if the court does not accommodate, time will accommodate him. What is your submission? When?
Up to you, Lordship, my lord. On.
When do you want?
First week of November. Next month, next month, my lord. In nothing.
Second, third week of November.
If 28th, your lordship, if your lordship is providing third, then 28th.
No, we are not giving any fixed date.
Okay,
We'll
ma-
leave it on register. Item number 23 and 24, na? Heard, Mr. What is the name? Jayanta? J. Medhi, appearing for the petitioner. Also heard Mr. N.C. Das, learned senior counsel assisted by Mr. A. Das. Learned counsel for
1, 2, and 3.
respondent number 1, 2, and 4, it is mentioned in
1, 3, and 3, your lord. In item 23.
1, 2, and 3. And in 4,
In 23, your lordship, only 3 respondents.
appearing for the respondents. Learned counsel for the petitioner seeks an adjournment due to personal difficulty, to which learned senior counsel for the respondent does not raise any objection. Hence, the prayer is allowed. Let this matter be listed in the third week of November on a date to be fixed by the registry. Same order in common order in 23 and 24.
24, 24. All the respondents, same your lordship.
Common order.
Oblige. Oblige.
25.
Some adjournment was paid for. Heard Mr. M. Mondal.
D, your lord.
Sorry. D. Mondal, learned counsel for the appellant. Also heard Miss, what is your name? Yes, Nushahari. Appearing for Miss M. Chaudhary, learned counsel for respondent number 3, who seeks an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. Learned counsel for the appellant does not raise any objection to this said prayer. Hence, same is allowed. Let this matter be listed
Your lordship,
in the
2-3 occasion, the matter has been listed for hearing. And is the old pending matter of 2016. So if your lordship,
suggested date.
your lordship, any hearing date on the last week of October, 30 or 28?
Last week we have fixed matters. On 8th of November. 6th of November, sorry. 6th of November.
Highly obliged.
26.
May I please, your lordship? Matter may taken some other day.
Why?
Mr. A.K. Gupta is another court.
Lordship, date may be fixed, your lordship, several occasions it
number
was listed for
26.
hearing, your lordship.
What is your name?
R.K. Mohanto on behalf of A.K.
Heard
Gupta.
Mr. R.K. Mohanto, learned counsel for the appellant. Also heard Mr.
A.R. Shom.
A.R. Shum, learned counsel for respondent number 2. Learned counsel for the appellant prays for an adjournment on the ground that conducting counsel Mr. A.K. Gupta is on legs in some other court. Considering the submissions made by learned counsel, the prayer is allowed. No fix.
Lordship, several occasions it was listed for hearing, but it was not reached, so the date may be fixed, your lordship.
No. Date fixing is a very dangerous.
Lordship, because it will not.
Let this case be listed
Any date first in November, your lordship.
in the first week of November,
Any date
in the
first week.
second week of November, on a date to be fixed by registry.
My humble prayer, lordship.
No, I have very bad experience of fixing date. More people, more lawyers would have been waiting by this time had I been fixing dates.
Lordship.
Therefore, let registry
First week of November. then.
first week of November.
Lordship.
Yes.
Obliged, Lordship.
Nobody is there for appellant.
Yes, ma'am. Last occasion also one appeared and took time, my lord, and
My lord, it is against concurrent judgment.
What is to be done? Because in civil cases, absence is may be dangerous. None has appeared for appellant on call. Heard Mr.
K.U. Ahmed,
K.U. Ahmed, learned counsel for
respondent number 1.
respondent number 1, and Mr.
I am for.
K.
the state of
Bhattacharya.
Assam. K.K. Bhattacharya.
K.K. Bhattacharya,
For pro forma respondents.
appearing for state respondents,
All the state respondents.
all the state respondents. Let this matter be listed.
4th week of November, my lord.
No fixed date.
My lord, last
Fourth-
chance may be
fourth
given,
week,
my
my
lord.
lord. Last
If they-
chance, as-
If they don't do anything next time, it will be dismissed for.
No, if you press for dismissal, it can be dismissed at any time.
Yes, my lord.
No, today, last chance may be given, so that next time it will be easier for us.
No, otherwise, otherwise also it is not difficult. Let this case be listed after 2 weeks on a date to be fixed by registry.
4th week of my lord.
Fourth week of
November.
November.
Okay.
Let,
Obliged.
on it, in the 4th week of November on a date to be fixed by registry.
Item 30.
May have, item may be taken up on November 1st week. Conducting.
Heard Ms. R.D. Majumdar, learned counsel for the appellant, also heard Mr. R. Chetri
For respondent number 1.
for
SK
respondent
Chetri.
S.K. Chetri,
For
learned
one.
counsel appearing for respondent number
1.
1. This matter could not be taken up for hearing today due to paucity of time. You're seeking adjournment? Okay,
That's what I was studying.
okay, learned counsel for respondent
Number 1.
seeks an adjournment on the ground of personal difficulty. Considering the submissions, the prayer is allowed. Let this matter be listed after
November
2,
1st week.
no, after 2 weeks on a date to be fixed.
Respondent
by-
1 is permanently disabled, lordship.
2nd week of November on a date to be fixed by registry.
Obliged.
32.
Paucity of time because second appeal. Yeah.
Second appeal. 22. Heard Mr. P.S. Deka, learned senior counsel assisted by
Yes,
P.S. Deka, learned counsel for the appellant. Also heard Mr.
D. Chaudhary
D. Chaudhary,
for respondent number 5 and 6.
appearing for respondent number 5 and 6. This matter could not be taken up today due to paucity of time. Let this matter be listed after 2 weeks on a date to be fixed by registry.
44.
The dated DPV council is on the legs in some other court today. Mr. R. Simswa.
Heard Mr.
G. Kosh.
G. Kaushik, learned counsel for the respondent petitioner. Also heard Mr.
R.K. Mohanto.
R.K. Mohanto, learned counsel appearing for
A.K. Gupta, respondent.
respondent. It is submitted by learned counsel for the petitioner that learned counsel for the petitioner, namely
R. Sensu.
R. Sensua, is on legs in some other court. And therefore an adjournment is prayed for. The prayer is allowed. Let this matter be listed after 2 weeks on a date.
Your Honor, first week of November. Later.
2 weeks on a date to be fixed by registry.
Oblige. Oblige.
Remaining,
Yes, actually, at our instance, by filing early hearing petition, it has been fixed. So it did. Because there are some urgency on our part because concurrent finding and in filing one writ petition, they have taken injunction that the amount which is to be disbursed, because over this land, Assam Mala road has been progressed.
okay. What is your name?
V.K. Borra, my lord. Appellant.
Heard Mr. V.K. Burwa, learned counsel for the appellant. Also heard Mr. S.K. Ghosh, learned counsel for the respondent, who submits that this matter was fixed today as a result of filing of an application
Early hearing.
by the respondent for expeditious hearing of this appeal.
That
Stop.
was allowed.
However, this matter could not be taken up today due to paucity of time. Stop. Let this matter be listed. Suggested date.
My lord, on November 9, 9 November is 11th of November.
11th.
Then 18.
Yes, 18th of November. Let this matter be listed on 18th of November as a fixed item.